May I please, Your Lordship.
Yes.
Lordship, I beg to pray for listing of a matter on 7th, Your Lordship.
7.
Lordship.
What matter is this?
Lordship, my salary has not been paid since 2011, Your Lordship. And other benefits also have not been paid to me. I've already
For admission?
Lordship.
7.
Lordship.
All right, 7.
Deep Lordship.
May I please, Your Lordship. Lordship, in item number 6, we had filed an IA on 10/1/2024. The same may be called for, Your Lordship.
Why? 10-1.
10/1, Your Lordship.
Why is it not been typed?
Lordship, there was some objection there in the registry, Your Lordship.
All right, call for.
Oblige, Your Lordship.
May I please, Your Lordship. My Lord, I pray for listing of a matter, my Lord, 2016 matter, my Lord, for admission. Next, my Lord.
16th. 16th.
16, my Lord. I live there.
May I please, Your Lordship. Lordship, I beg to mention for unlisted call for Lordship.
Unlisted.
Yes,
What matter?
Lordship. It was fixed for today, Lordship, but unfortunately, matter is not listed, Lord.
What matter?
Matter relating to suspension, Lordship.
Suspension matter. You're already suspended.
Yes, Lordship.
It will come as a listed matter. It will come as a listed matter.
But,
What do you want? What interim orders do you want?
no interim order, Lordship.
Then why unlisted?
No, Lordship, for quashing the impugned order.
So you want it on the first day, quashment.
Yes, Lord.
First day, without giving notice to the other side.
No, Your Lordship, to obtain instruction, Lord.
No. Let it come as a listed matter. As per the registry.
May I please, Your Lordship. My Lord, item number 27, my Lord. The respondent side has filed their affidavit in opposition yesterday, my Lord. I could not go through this.
At the request of the learned counsel for the petition, the matter stands adjourned for 2 weeks.
1 week, my Lord.
2 weeks. We'll give you 2 weeks to file the rejoinder affidavit to the affidavit in opposition filed by the respondent.
If necessary, my Lord, I have.
To complete his instructions and file rejoinder affidavit if necessary.
May please, I beg to mention listing order column, my Lord. The matter was listed, my Lord, last 2011-2020. Thereafter not listed.
For what purpose?
My Lord, regarding the selection and appointment, my Lord.
Why do you want it for orders?
Orders, my Lord.
Why?
Well, my Lord, still not the 4 week time is allowed, my Lord. But 4 week, 10 weeks already.
Let it come for admission then.
Private, where is maybe private respondent, where is APR or not, that was not confirmed. So it is order column.
You mention it, you'll fix a date. Yes.
Yes, my Lord.
Date at a cycle orders.
My
Yes.
please, Lordship. Lordship, in regard to item 37 of the daily list, my Lord, we have filed one additional affidavit on 31/2024, my Lord. That may kindly be called for, my Lord.
No. You have filed by on whose behalf?
On behalf of the petitioner, my Lord, there was a direction by this honorable court passed on 9/1/2024, my Lord. Asked by your Lordship only, my Lord. So we have filed
Let it come next week along with the additional affidavit.
It has been listed today, my Lord.
Your additional affidavit is not here. Let it come along with the additional affidavit.
If it is possible to call it for, my Lord, only, my Lord, some additional documents are placed, my Lord. That is the only.
No, you have it listed along with the additional affidavit. Item 37 to be listed again on 9th of February. It is submitted that an additional affidavit has been filed by the petitioner. The registry will list the petition along with the additional affidavit stated to have been filed.
Yes, please.
Please, back to mention for listing of a reading for admission.
Admission. Let it come on 21st February.
Number 1.
They are seeking for some further time. They have sought for opinion from the AG. That is evident. Otherwise, my Lord, I have got a judgment, my Lord, latest judgment, which has been relied upon by the division bench also in similar cases. It is, my Lord, 2020-17 SCC 465. There are 13.3.
2020.
2020-17 SCC, volume 17 SCC 465. My Lord, para 13 will be relevant, my Lord. 13.1, 13.2, 13.3.
What does it say?
My Lord, so far as my Lord 13.3 is concerned, it says that, my Lord, in case of, my Lord, if a candidate is by any means, my Lord, is deprived of, who is otherwise eligible, on merits. In that case, my lord, the honorable court has got the power to mount the relief and direct the authorities to admit that particular candidate in the next session, if required by increasing the seats. There's a specific direction. And my lord, this particular case came up, my lord, to discuss, my lord, the issue as to what will happen in a case, my lord, when such admissions are to be made after, my lord, 30th of September. That is the last date fixed by the honorable court, honorable Supreme Court in Middledur's case.
Now, you have already taken a decision to accommodate him, isn't it?
No, that decision is not there.
Not here.
Yes. But difficulty is, my lord, our hands are tied, my lord. If the session is already started, in between we cannot, and
All right,
also we
then,
cannot take a decision that we will have to give admission in the in the coming session. Only, my lord, if the honorable court directs, my lord, it becomes convenient for us. And this particular judgment will cover the field, man. He's holding the field as on date. So next
We'll have
week,
it
my
on
lord,
7th,
yes.
7th February.
Can it 7th of February?
No, 9th or June.
Huh? 8, 7th.
What's your 9th, my lord? That is
9th, all right, 9th, 9th February.
Oh.
Let the matter be listed again on 9th, enabling the respondents to complete their instructions in the matter. Yes,
2017,
Only- The only thing that if at all, your lordship directs in the, on the basis of this judgment, it is accommodated also, since he should be, I think, some compensation on the way of your lordship.
we'll
Yeah,
we'll
Because
consider,
he has already given the admission fees earlier. That has to be
That can be adjusted, man.
we'll consider that if we pass an order.
much.
With that, we'll do like. do like-
Please, your lordship.
Yes,
My lord, this is my lord relating to pensionary benefit, my lord. The petitioner is paid my lawyer pension by deducting his service.
yes, some instructions are awaited.
My lord, there's a judgment of this division bench, my lord, pertaining to secretaries in the Panchayat department who were appointed way back in 93. However, their services were regularized in 2003. So their date of entry, as per the division bench judgment, has been considered from 2003 onwards and not prior to that. This pension qualifying service would start from 2003. In this matter also, my lord, he was granted the scale of pay subsequently, my lord. If my lord would have a look at the PPO, at page 64. He has not annexed his appointment order, my lord, first of all, so he's relying on the PPO.
Yes.
Issue notice. 64 does not PPO. Sorry,
PPO is a, 64 is a,
well,
Order.
68 is the PPO, I'm sorry. So his date of appointment is 61, my lord, but it is not against a sanction post. He was granted the regular scale of pay from a later date, which is at 1976, my lord. The department has passed a order at page 87.
yeah, how much, he's getting pension now,
Yes, your lordship,
Proportionate,
proportionate,
my lord,
after deducting that
my lord.
yes, my
15
lord, that
years.
time period.
My lord, kindly see page, my lord, 72, my lord.
Mhm.
Petitioner earlier approached before this honorable court.
Hmm.
Page 74 is the operating part, my lord. Para 4 and 5, my lord. May I read, my lord?
Yes,
My lord, considering the grievance raised, we are of the view that the interest of justice would be made on the reason, on a reason order being passed by the Commissioner, Panchayat and Rural Development Assam on the said representation of the petitioner dated 9/3/2022, whereby a claim is made that he had a continuous service of 35 years, 3 months and 10 days. Para 5, my lord. The commissioner to call for the record to verify and justify as to what is the continuous service of the petitioner. If the record reveals that the continuous service of is 35 years, 3 months, 10 days, and accordingly, the petitioner entitled to full pension, necessary consequential order thereof be passed. So, my lord, it is clear, my lord, the judgment that my lord, length of service is to be taken into account. And the, my lord, kindly see page 68.
It is the division bench order.
My lord,
Yours.
I have also relied, my lord, division bench.
Where-
order.
where
My
is
lord,
it?
This is the, my lord, different order, my lord.
Page
My lord,
number,
Page, my lord, 54.
54.
Page 54.
This is a different one.
Page 54. Page 27 is the starting, my lord, and the 54 is the operating part, my lord. Here, my lord, in this case, my lord, the petitioners, in this case, my lord, were appointed in 1960, 61, and 62. Their service were provincialized in 1991. Then they retired, my lord. Kindly see, my lord, the para 54, last part, my lord, last sentence, my lord. We are.
Para 54.
Para, sorry, page 54,
Hmm.
last sentence.
No, last sentence.
We are there,
Last 5 lines, my lord.
last
he means
5
to
lines,
say.
my lord. We are therefore,
Yes, we
we are therefore of the considered view that the benefit of the provisions of the Act, including those for pension and other retirement dues, would be available to the provincialized employees in service on and after 1/10/1991 on the basis of the length of their service reckoned from the date of their initial appointment. My lord, initial appointment, the word is very important, my lord.
Initial
Initial-
appointment against a
Well,
sanctioned post, my
let me
lord.
complete, my lord.
He's
Then
forgetting the term
my lord,
sanctioned post.
Let me complete, my lord. Then, my lord, this judgment was challenged before the Honorable Apex Court, my lord. Kindly see page 56.
Hmm.
Page 56. My lord, SLP was dismissed, filed by the state, my lord. Then your lordship would come to page 57. Notification was issued by the, my lord, Commissioner and Secretary to the Government of Assam Pension and Public Grievance Department. Page 57. Pursuant to the division bench judgment, notification was issued on, my lord, 17 March 2021. Pursuant to this notification, the petitioners and other employees are paid pension, my lord. My lord, may I read, my lord, para 2, second para, my lord.
Hmm.
Now, in terms of the judgment referred above, the Governor of Assam is pleased to order that the benefit of the provisions of the Assam Panchayat Employees Provincial Election Act 1999, including for pension and other retirement dues applicable to the state government employees, would be applicable to the provincial Panchayat employees who are in service on and after 1/10/1991 on the basis of the length of their service, reckoned from the dates of their initial appointment in the service of pension. Here, my lord, initial appointment, not, my lord, from the date of scale, my lord. Then your lordship would come to page, my lord, page 59. Due to non-payment of pension, the petitioner approached before this honorable court, my lord, by filing writ petition in 2014 along with some other person, my lord. Here, my lord, operating part, page 64, my lord.
Hmm.
Page 64, my lord, my lord, my lord, 3. From the third paragraph, last time, my lord, here also mentioned that from the date of their initial appointment as a special case not to be treated as precedent. So date of initial appointment is directed to be considered, my lord. Then your lordship, PPO was issued, page 67.
What is that other division bench judgment?
My lord, I have related some judgment, my lord. Kindly see, my lord, page, my lord, 78. Page 78. I have annexed the judgment, my lord. Here, my lord, the similar question raised, my lord. There, some Prabhu Diakson.
Which paragraph?
My lord, page 14 and 15 are relevant, my lord. 4 and 5, sub-headings. The date of
You are
initial
giving me,
appointment
you are
application.
giving me from page 5 onwards of the judgment.
I'm so sorry, my lord. That's my.
You appeared in this matter.
Yes, your lordship.
Then you should have relied on it.
My lord, it is a my lord, different case. My lord, it is a case relating to the whether new pension scheme or old pension scheme applicable to the my lord
Hmm.
petitioners therein, my lord. And in this case, my lord, single bench judgment considered that the total length of service, and the division bench, my lord, upheld this judgment, my lord.
We'll have to examine this matter.
The point here is the date of initial
Malad, I
appointment,
see
we do
case-
not differ with that, but date of initial appointment against a sanction post. Let him show his appointment order. He is not
No, my
annexed
lord,
it
they
along
have
with his writ
considered, my lord,
petition.
they have mentioned in the PPO, my lord.
He is not even
It-
annexed
it
it
is-
regularization order.
PPO is not a disputed, my lord. It is, my lord, issued by the, my lord, authority, my lord. That cannot be disputed, my lord.
Let him show when he was appointed against a sanction post.
But this is with regard to ex post facto creation
lord,
of.
my lord.
Totally agree, my lord.
Different
I
case, my
totally agree. But however, my lord, in this particular case, what had happened is that they were initially appointed in the year 1993. And they were seeking that we should be governed by the old pension. The division bench upheld the judgment of the honorable single bench, but however, it made a observation that his date of entry into service would not be counted from 93 onwards. It would be counted from the date on which his services were regularized against a sanction post.
Paragraph.
That is page number 14 and 15, my lord. Page number 14 and 15. I'll just,
Yes, 14.
Page 15, 5, Pension Rules 1969.
Hmm.
Rule 31 of the Assam Services Pension Rule 1969 entitles a person for pension when the service is under government. Secondly, the employment is substantive and permanent. And thirdly, the servant must be paid by the government. In the case in hand, as discussed and determined herein above, the service of the GP secretaries are required to be treated to be a service under the government with effect from 30/5/2003. This was the date, my lord, when the order was issued by the Commissioner PNRD, and or from the date of issuance of respective office order by Chief Executive Officer pursuant to communication dated 35/2000.
This is on a different. You can't
My
just pick up one line and say that this
My lord.
is what is held. This is not the ratio.
But my lord, the date of initial appointment will be considered from 35/2003.
Where is the finding? Where is the finding of the court?
My lord, the last line, the next paragraph. A co-joint reading of the communication dated 35/2003, 44/2006, and 28/3/2018 leaves no room of doubt that posts were created by the state ex post facto with effect from 35/2003, and therefore it can safely be concluded that the service of the petitioner is to be treated as an appointment in a substantive post with effect from 10/6/2003. Whereas he was appointed in 1993, my lord, which is at page
That is an inference. There's no finding on the fact.
page 36.
There's no law to say that the decision in Fazile Rabbi is only qualified to be accepted only for substantive appointments. Where is the finding?
But my lord, date of initial appointment has, but one issue, one more I would point out, my lord. If my lord would read Fazli Rabbi Fazle Rabbi has not discussed about.
We'll hear it, we'll hear your matter. Matter be listed on, have we issued notice? Third Learned Council for the parties issue notice. Returnable. On 20. Mr. Henrik appears for the PNRD.
PNRD.
PNRD. Mr. Borpuzari for finance,
Finance, my lord, R3 and 7.
R3 and 7. Pension, Mr. Chakraborty. And Zilla Pori for PNRD. Since learned standing councils have already entered appearances, notices are waived. However, extra copies be furnished within a course of 1 week from today. Matter be listed for admission hearing on 20.
I have already furnished, my lord. Highly obliged, your lordship.
Although the department has sought for some time in this case, the petitioner is seeking the advantage of the judgment passed in Upen Das matter, minimum of case law. His name was not sent to the finance department. That's their limited grievance. So,
Any objection?
time laga.
Mr. Hendik, Learned Standing Council, PNRD, please. Further time to complete his instructions, MSP Viswas, Learned Council for the petition does not object. List matter after 2 weeks.
May please your lordship. Lordship, the case of the petitioner is that earlier they filed a writ petition, lordship, as the members of the petitioner association have been arbitrarily and illegally denied the benefit of the upgradation of the post of scientific assistant to demonstrator. And
Will
consequently,
issue notice at this stage?
Yes, sir.
Third Learned Council for the parties issue notice, returnable 4 weeks. Mr. D. Upamanu for respondent 1, 2,
And 4.
and 4. Mr. R. Borpuzari for respondent 3.
Respondent 3, my lord.
Since learned standing councils have entered appearances, notices of waived, extra copies be furnished within 1 week from today. List after returnable date.
Highly obliged.
Petitioner was appointed in 1999 also.
Yeah.
Thereafter petitioner service was terminated and thereafter it was set aside and thereafter again regularized. Now again regularized in 22, Lordship, giving effect of prospective effect. They are entitled for pension and everything. Analogous repetition where already notice has been issued. WPC number 6793 of 2023. It may be checked with that, Lordship, but this is notice will be issued. 6793.
Yes.
No, I'm paying for responder 2, 3, and 4, my lord.
Is it connected to the earlier
That judgment, same,
yesterday's?
that yesterday's one, my lord. It was, earlier it was regularized, it is, then the services, reappointment was done.
Okay.
Not reappointment, Lordship, termination was set aside.
Termination was,
And thereafter, Lordship, they have stated that termination order was page 52.
All right, we'll hear it along with the other batch of writ
Lordship,
petitions. Heard Learned
WPC
Council
6,
for the
no.
petitioner. Issue notice, returnable 4 weeks. Mr. S. Pora, it is for.
respond number 2, 3, and 4.
2, 3, and 4. Elementary, Mr. Katonia and Mr. Borpuzari for respondent 5. Since notices, councils have represented the respondents, notices are waived. Extra copies be furnished within 1 week from today. Matter be listed along with
6793
WPC 6793,
of
2022
23.
and 23.
23.
Luckily, these two are there. Along with other bunch of writ petitions. as it is submitted at the bar that the issue involved is similar to those urged in this 8 bunch of writ petitions.
Obliged.
Well, other bunch of it that is numbered is different.
No, আমার বাচ্চাগুলো check লাগে, I check লাগে।
Then it's okay.
You check up and tell us.
Not that, that is petition
we have-
number 5281 of 2016.
5281.
5281 of 2016.
Lordship,
Last,
I have already
yesterday's
filed,
number.
I have already filed writ petition on the same tax. These are writ petition 6793 of 2023, and there is an order to list this matter along that. That is why Lordship 6793. Otherwise, it make a chaos, Lordship. Obliged.
Yes.
May I please the lordship? Lordship, kindly have a look on 8124 order, my lord. And everything, Muson stays, my lord.
Nolbari.
Yes, my lord. Currently, we have filed one IM, my lord, and chairman of the Nalbari board, we have been treated as respondent number 5 in this case.
Heard Mr. Tekka, learned counsel for the petitioner, Mr. C.S. Hazarika for the respondents 1, 2, 3, 4. Stop. By this I, the petitioners pray for airing of Nolbari Municipal Board as a party respondent in the writ petition. Stop. This application is filed pursuant to the directions of this court on pursuant to the order dated 8/1/2024. Any objections? Since no objections are raised by the respondents at this stage, this IA is allowed. The Nolbari Municipal Board, Executive Officer, Nolbari Municipal Board, and Nolbari Municipal Board represented by Chairman are arrayed as party respondents. It should be
Respondent 5, my lord.
4 and 5. Registry to the applicant, the petitioner will file amended course title before the registry within 1 week from today, showing the names of the newly added parties. Stop IA accordingly stands allowed and disposed of in the writ petition 38 in view of order passed in IA number so and so. Nolbari Municipal Board represented by Chairman and Executive Officer, arrayed as respondents 4 and 5. In the writ petition, petitioner will file amended course title in the registry. Pursuant thereto, the registry will make necessary endorsements if required in the case record. Matter be listed after 3 weeks.
Obliged.
Okay, executive officer has been made a party already.
Yes, sir.
Yeah, please, Lordship. The petitioner was the assistant teacher of National ME School, and his service was also regular. Lordship, the respondent to place a record in respect of the case.
Yes.
The proposal is pending with the finance department, my lord. I've received the instruction. My lord, may at least the issue notice, my lord.
Yes, madam.
Lordship, it was several times as a place before the respondent, but they have not considered.
Well, issue notice at this stage. Heard learned counsel for the parties issue notice returnable 4 weeks. Mr. N.J. Khatonia appears for the education, secondary education.
I'm order for it. Yeah, okay. You know.
Elementary Education Department. Mr. R. Bortuzari for Finance Department.
Respondent 2, my lord.
No, we have indicated finance
One of
since the respondents.
My 1 also, 1 and 2, my lord. I'm sorry.
Since the departments are represented by the standing council, notices are waived, however, extra copies will be furnished within 1 week from today. Steps on respondent 7. by registered post AD along with usual course. Trustee is also permitted. Matter be listed after 3 weeks.
Lordship, and similar matter is there, another one, WPC number 156 about them. This matter will listed along with this case.
When is that matter listed?
It was in the court number 26.
You have to make a mention. We'll get it listed along. Yes.
Obliged.
Made in the law. But in this case, my friend was.
Transferred.
My life.
Yes. Education.
But I have not received the instruction yet, my lord.
My difficulty is that I am not getting my salary since 1923. As I have not been released by the Sarva Shiksha Abhiyan Mission, I have not been able to join in the new place of posting. I am doing my duties as in the Sarva Shiksha Abhiyan Mission, my lord, as
You are doing your duty as what?
CRCC, my lord, Cluster Resource Center Coordinator, my lord.
Were you ever a teacher before?
My lord.
Where what is your initial appointment?
My initial appointment, Lord, you will find at page 15, my lord.
Hmm.
Page 15, my lord.
Stipendiary teacher. Then what happened?
Thereafter, my lord, my service was regularized. I was transferred from my lord, from the Mohendra Padgiri LP School to my lord, Bongaon High Secondary School on 2018. Since then, my lord, I was working at Bongaon High Secondary School, my lord. But by the imprint order at my lord, 8/8/2023, the petitioner was transferred from Bongaon High Secondary School to Peradhara High Secondary School.
Yes. Now, what is that order you have enclosed? Order of a court?
Order of court, my lord, page 19.
Hmm.
It says that, my lord, if for my lord, rationalization, somebody is to be transferred, the junior persons should be transferred. Below me, my lord, there are 8 persons, my lord, in the school, but they have not been transferred. I have been picked and choose for time being transferred.
Then
The students, my lord, approached the deputy commissioner as well as the principal of the school. I personally approached the, my lord, competent authority, my lord, by filing representations. Till that, my lord, they have not considered my representation.
where is your representation?
Yes.
Release.
Who is supposed to release you from Bongaon?
My lord, district mission coordinator, my lord, TMC.
He has not released you.
From, not from Bongaon, my lord, from,
Hmm.
my lord, the duty of, my lord, cluster resource coordinator, my lord.
No, that is what you are saying in your representation. That you could not be released. You said you could not be released.
My lord, the school cannot release me, my lord, without being released by the, my lord, Sarva Shiksha Abhiyan Mission, my lord. But the school has released me in violation of the Sarva Shiksha Abhiyan guideline.
Hey, Mr. Khaturiya, you get your instructions
Yes,
here.
my lord. I have already communicated with the department, my lord, but till today, my lord, they have not provided.
Mr. Bora, anything to submit?
Our name has not been reflected, my lord.
Huh?
Just now I came to know, name has not been reflected in the cause list, my lord. Just
Copy
now I
was
came to know
served,
that
my lord.
the
Copy
SSA has
was
been made
served.
party, my lord. No, no, name is not reflected in the cause list.
SSA is a party.
Party,
Party,
but
my
name
lord.
has not been reflected in the cause list. Just now I came to know that
Okay.
this is respondent of 4 is SSA.
GA Assam is also party, my lord.
Heard Mr. Ayat Soikia, learned counsel for the petitioner, Mr. N.J. Katonier, learned standing counsel, secondary education, and also Mr. S. Bora, learned counsel for
SSM.
SSA. Stop. Learned standing counsels have submitted that further time be granted to obtain instructions in respect of the grievances raised by the petitioner. Stop. Let the matter be listed again after on
So that may be given, because he's not getting salary since.
on 16th
Yes, my lord.
February, by which time the required instructions may be placed before the court. It is further submitted that the what current salary has not been released to the petitioner. Stop. It is made clear pendency of the writ petition shall not be a bar for the authorities to consider the claim for release of current salary. Matter be listed again on 16 February. Names of all standing councils, including SSA, be reflected by the
SSA,
registry in the
SSA.
cause list. Yes.
Obliged, my lord.
It is a lot. My lord, presently, my lord, I am working as the research assistant, my lord, under SCERT.
Hmm.
And my post is under the centrally sponsored scheme on teacher education for restructuring and reorganization of the director of SCRT. My lord will find my promotion order at page 30.
Yes.
By way of this order, I was promoted to the post of research assistant SCRT, Assam Headquarter Establishment, Kahilipara, white letter dated 13 February 2017. That letter, my lord, will find at page 28.
Hmm.
By way of this letter, my lord, the 83 number of posts were created under this centrally sponsored scheme. And my post is at serial number 13. This is research assistant at page 28.
Hmm.
And my next higher post is at serial number 10. That is assistant research officer, my lord. And pursuant to that scheme, my lord, a service order was framed to govern the service conditions of these 83 numbers of posts. And that service order also will find at page 31. This page
Yes.
31 is the service order. And the clause 2H, it is defined the member.
Hmm.
Member means the member of the Assam Education Research Training Gazetted Service, including the post created under the restructuring and reorganization of SCRT Assam. That means I am governed by this service order. And my lord, at page 35, page 33,
Yes.
clause number 8, assistant research officer, this is the next higher post. This post shall be filled up by promotion from the post of research assistant SCRT Assam. And at page 40 and page 35, for filling up this post, the incumbent has required 2 years of regular service in the post of research assistant that I have, my lord. But my lord, now the department has initiated a promotional process, whereas the other persons amongst the 83 categories have been considered for promotion to their respective post, but my name has not been recommended and I am not been considered on the ground that a writ petition is WBC number 2177 of 2021. Due to pendency of this writ petition, my name has not been recommended, madam. And the subject matter of this writ petition relates to my Jorhat campus, and in that writ petition, the promotion is one Hemchandra Rava is under challenge, my sir. So that writ petition is nowhere connected to my promotion.
What you are now research assistant.
Assistant, my lord, under the centrally sponsored scheme, my service conditions are governed by the service order of 2017.
Is there a combined gradation list of research and statistical assistant?
My lord, our services are governed by this service order, my lord. And there is only 2 posts of research assistant. One is, and now the one is.
You come to page number 46.
My lord.
Para 3, para 3. Challenge in the connected writ
Yes,
petition.
connected writ petition is with regard to the final gradation list of statistical assistant. of the direct SCRT, the direct SCRT headquarter establishment in SCRT Jorhat under Directorate of SCRT Assam.
So,
This is-
so from the final gradation list, is it a combined gradation list of research and statistical assistant
This is the gradation list of statistical assistant, my lord,
only?
only, my lord. And I am the research assistant.
And for filling up that assistant research, what post you want to promotion? Assistant research officer.
Yes, my lord.
Are statistical assistants also eligible?
No, no, my lord. They are not falling under this centrally sponsored scheme, my lord. I am working under this scheme. This or service order is specifically framed for governing our service condition. And Lordship will find the at schedule 1 at page 40, Lordship will find the name of the post.
Hmm.
There is no statistical assistant in this centrally sponsored scheme. At page 16, that it is assistant research officer.
Now, where is that order of the government saying that the to pendency your
My
case?
lord, I have verbally informed, my lord.
Oh. You filed a representation?
My lord, since my lord, my right to consider for promotion.
Okay,
is there,
who's
that
appearing?
are-
Anyone for the respondents?
I'm agreeing with that.
And my lord,
His
Yes.
claim is for promotion to the next higher post. What is the stage of promotional process? Has it been initiated?
I have no,
as per
Today
my instruction, it will initiate shortly, my lord. Page paragraph 19, I have made a categorical statement. And lordship kindly turn to page 47 for a moment, my lord.
47.
Yes, my lord. This is the part of the order that I have filed in another writ petition.
Hmm.
And my lord, the second last paragraph, in view of the above, it is clarified that the interim order dated 30/11/2022 passed in the writ petition shall not affect the service benefit which may accrue to the applicant, that is me, my lord, who is discharging services as a research assistant under the centrally sponsored scheme. So there is clear and categorical direction from this honorable court. Thereafter, my lord, my promotion has not been done.
This is passed in an IA.
Yes, my lord. In earlier, okay, that Limpi Bora filed two writ petitions, my lord. The one writ petition is 7626 of
All right,
2022.
let the writ petitions be listed together.
My lord.
Heard, Mr. M. Dekar, Mr. N.J. Katonier for respondents.
it's not a one, my lord.
Respondent 1.
Two no hanging.
Who's for 2?
Hmm.
Who-
Mr. B. Gogoi, my lord.
Mr. B.
B.
Gogoi. Please inform him. We are recording.
Yes, my lord. Yes.
Mr. B. Gogoi appears for the respondent number 2.
Yes,
Since learned councils are represented, notices are waived. We'll not issue notice at this stage. Let them get their instruction.
My lord.
They submitted that the petitioner who's working as a research assistant is eligible to be considered for promotion. He is working as assistant, research assistant, who is eligible for consideration to be promoted to the next higher post of assistant research officer under the Directorate of SCERT. Stop. Learned counsel for the petitioner has referred to the service order, namely Assam Education within bracket research and training -gazetted service order, which it is submitted that governs the service conditions of the petitioner and other similarly situated employees working under the SCERT. Stop. It is learned counsel for the petitioner referring to clause 6 of the said order submits that for the post of assistant research officer, the same is to be filled up by promotion from the post of research assistant SCERT. Stop. It is submitted that the department is proceeding is contemplating to fill up these posts fill up other posts, but for insofar as the writ petitioner is concerned, he has been verbally informed that his case is not considered in view of the pendency of a writ petition being WPC 7626 of 2022 filed by, she's also working
She's working at Jorhat campus, my lord.
under SCRT,
Yes, my lord.
another employee working under SCRT but posted in Jorhat. Stop. In the said writ petition, an IA was filed by the present petitioner, which came to be disposed of, modifying there was some interim order,
Yes, my lord.
modifying the interim order to the extent, to holding that the interim order dated 30/11/2022 passed in WPC 7626 of 2022 shall not affect the service benefits which may accrue to the applicant, namely within bracket the petitioner who is discharging his service as research assistant under the centrally sponsored scheme. Stop. It is under these circumstances, the petitioner is again before this court, praying for appropriate directions to the petitioner, to the respondents for consideration of his case. Stop. Perhaps since the learned standing councils, let instructions be placed before the court as to the apprehension expressed by the petitioner. Placed again on, when can you get it?
After 10 days, my lord.
After 10 days. On 21st
Yes,
February. The interim order, if required, will be considered on the next
My lord.
returnable date.
I am deeply obliged.
Although notices are not issued, extra copies be furnished
My lord,
to
I'll-
the respective standing councils.
May I please, item number 10 and 11 is similar methodology. There is some mistake in the synopsis of item number 10, so kindly take up item number 11 first.
11.
Yes.
Yes.
Lordship, petitioner Sharina, we are working as assistant secretary in Assam Higher Secondary Education Council. They are retired now, Lordship. Another one series from 20 to 36, Lordship, are the promotional orders of the petitioners, Lordship.
We will issue notice at this stage.
At this stage, notice may be issued.
Well done, counsel for the parties issued notice written above 4 weeks. The petitioners are retired employees of
Assam Higher Secondary Education.
Assam Higher Secondary Education Council who are claiming benefits, who are before this court praying for appropriate orders for a direction to provide the pay scale, to provide them the appropriate pay scale
Yes.
from the date of their joining in the post of assistant secretaries, and to give consequential benefits, including retirement, retiral and pensionary benefits by calculating their salary in the pay scale of rupees 6600-12625 from the date of their joining as assistant secretaries. Mr. Who appears?
I'm for respondent 1, my lord.
Mr. Attorney appears for respondent number 1. And for High Secondary Council, Mr. Chutia.
Yes, my lord.
Mr. T.C. Sutia appears. Please inform him. T.C. Sutia appears for respondent 2, 3, 4,
2,
5.
3, 4, and 5, my lord.
5. Let notice be issued, returnable 4 weeks. Since the standing councils have entered appearances, notices are waived. However, extra copies be furnished within 1 week from today. Yes, Mr. Sutia.
Oh, no copy has been sharp to me, my lord. Anyhow, I can appear on 2, 3, 4, and 5, my lord.
No, no, 4. Oh, yes, sir.
2, 3, 4, and 5.
5 only.
Yes.
He will serve.
Please obtain instructions in the matter. Please serve extra copies.
Yes, yes. Lordship,
Same order in item, both the matters.
Lordship, item number 10, Lordship, in the synopsis, I want to strike out one portion of the.
You file a fresh synopsis in court. You file a fresh synopsis
Yes, yes.
if you want.
Yes, yes. Lordship.
Here the issue is relating to prolonged suspension of the petitioner. But he was placed under suspension initially on 27/9/2018 following his arrest. Having my lord being allowed to go on bail, he reported to the authorities on 22/4/2020. 3 disciplinary proceedings were initiated. Enquiry reports came in the year 2022, my lord. I approach this honorable court. There is an order not to impose any penalty during pendency of the repetition. Now, my lord, from even after submission of the enquiry report till today, I have been kept under suspension. My disciplinary proceedings, my lord, relate to an incident in Ranchi.
This proceeding was challenged by way of another.
The
writ petition.
disciplinary proceedings have been challenged, my lord, after the submission of the enquiry report.
Very well, then we connect this writ petition with the other.
My lord, yes, otherwise, my lord, this prolonged suspension which I'm undergone even after submission of the enquiry report and my lord, my criminal proceedings are going on at Ranchi. My headquarters being here located at Jorhat. Without my lord, at 50% of the salary, they have not increased my subsistence allowance also. Perhaps they require, in the meantime, my lord, they require to pass necessary orders on that also. Otherwise, it's
So
impossible
who's
to provide
appearing for
my
the
lord.
respondents?
So the central government council would appear, my lord.
Where is the council?
I would not know.
Heard Mr. R. Mazumdar, learned counsel for the petitioner. The petitioner is employed as what?
Assistant Commandant, Private Secretary in the Central Reserve Police Force.
Assistant commandant
Private Secretary.
in,
Okay. Motion.
sorry, assistant commandant,
Private Secretary.
private secretary, personal secretary,
Personal Secretary, I'm sorry. Personal Secretary.
personal secretary.
In the
Under
central-
the CRPA. And is posted at
My lord, now he is posted at Jorhat.
Jorhat. Petitioner was placed under suspension pending departmental proceedings. It is submitted that he was initially suspended on
27/9/2018.
27/9/2018
18.
with effect from the date of detention, namely 2009/2019,
My lord.
as he was arrested. As he was taken into custody in connection with Nagori PS case number 157 of 2019 under section so and so, so and so. It is submitted that the petitioner has been under prolonged suspension for a period of 4 years. Stop. It is also submitted that his subsistence allowance as per the rules have not yet been released.
But it has been released. They have not.
As per rules.
As per rules, it has been released, but they have not considered the increasing the amount to 75%.
That's what I said.
They rejected it, my lord, at one point of time.
That has not been released to the extent permissible under the rules.
My lord.
Stop. Let notice be issued returnable 4 weeks. MS A. Gayon appears for all the respondents. Same is learned CDC appears for respondents. Notices are
All
waived,
the
however.
respondents.
All
All my.
notices are waived, however, extra copies be furnished to the learned standing council within a period of 1 week from today. It is also submitted that a writ petition is pending. A writ petition filed by the petitioner looking to challenge the disciplinary proceedings drawn against the petitioner is also pending. Accordingly, let this writ petition be listed along with WPC number
360 of 2023.
360 of
2023.
2023 after 4 weeks.
Established. The period of suspension, I have said that 2018 should be 19.
You said 18.
I said 18, my lord, but he was arrested in 19. My mistake.
It is 18 or 19?
19.
19, 2019.
Bless you.
Yes, Mr. Goswami.
My lord, grievance is for the 6 months salary, my lord. That has been withheld. My lord. Petitioner was regularly appointed in 1197 number Shimalia Balika LP school, where there was only one student and three teachers. Therefore, his services were utilized in a different school, 423 Jatiram Milon at Tamata.
We'll have to issue notice, I think.
My lord, only notice is required.
Had learned counsel for the petitioner, Mr. X.S. Goswami. Issue notice, returnable 4 weeks. Mr. N.J. Katonia appears for all
All are responsible.
all the respondents. Since the learned standing counsel represents the respondents, notices are waived, our extra copies be furnished within 1 week from today. Let the respondents complete their instructions and file necessary affidavit if so advised.
Ma'am.
In the meantime,
Ma'am.
matter be listed after returnable date.
Maybe your lordship. Matter relates to pensionary benefit in respect of unmarried dependent daughter. As per amendment rules.
Yes, who's for the respondents?
Karbi Anglong, Dima Hasao. Karbi Anglong is Dima.
Karbi Anglong,
Dima Hasao.
Dima Hasao, please get your instructions. No, it is Karbi Anglong or Dima Hasao. Huh?
Dima.
Then why have we added Karbi Anglong?
He was, the father of the petitioner was working a full agriculture education. From
Under what? Under Karbi Anglong or Dima Hasao?
Karbi Anglong.
Then why are you erasing Dima Hasao now? Who's for Karbi Anglong? Who's for Karbi Anglong? You're for Karbi Anglong. Please get your instructions in the matter. Why?
Lordship, it's Dima Hasao, Lordship.
Huh?
Dima Hasao.
So he says Karbi Anglong.
No, Lordship. Treasury Officer Dima Hasao.
And except for lordship.
Assam University, Lordship.
Huh?
Assam University.
Annexure 4.
Yes, Lord. That was the last pension payment order issued to the mother of the petitioner, lordship. And mother of the petitioner expired in the year 2021.
Then who's for NC Dima Hasao?
RM Das.
Please inform him. We'll take it up after a while. Let him come. Have you served copies on the standing council? Please call him. Take it up.
Matter pertains to the non-consistent statement of the petitioner despite suspension was issued on 13/7/2023. And the petitioner was arrested in connection with the case, and he was after release on 28/8/2023. Due intimation was given to the respondent authority with a pair to reinstate him, but no any so-called nor memorandum was issued, nor any reinstatement to the petitioner as on date despite the last
Yes.
6 months ago.
What instructions? Any?
I'll take notice, Lord.
No notice. Get instructions. It's only a question of he's asking for review.
Yes.
And reinstatement. So get your instructions.
I'll get it.
The writ petition is filed by the petitioner putting to challenge the continued suspension of the petitioner. By which order?
37, Lordship, page 40.
Huh?
Page 40.
40. By the order dated 13 July 2023, whereby he was placed under suspension. Pending trial of departmental proceedings. It's under 6(1).
Lordship, it is not provision mentioned, but it may be deemed suspension.
No, but it says pending
There is nothing mentioned.
It is submitted that the petitioner was taken into custody in connection with ACB PS case number 51 of 2023 under section 7 within bracket A of the PC Act 1988 on 12/7/2023. Stop. Subsequently, he was released on bail on 28/8/2023. This intimation was also submitted by the petitioner to the Department of Environment and Forests by his representation dated 1/9/2023. Stop. In spite of such intimation, no review has taken place and the petitioner is still under suspension. Subsistence allowance received. Accordingly, let the respondents obtain the instructions as to whether any review in respect of continued suspension of the petitioner was undertaken by the department. Stop. Mr. Borthakur appears for the forest,
All forest
for
department.
all the respondents as a standing counsel, and he will obtain the required instructions by the next date fixed. Placed again on twenty-first. Can you get it on 21st?
Yes.
21st. Yes.
Sorry, your lordship, maybe
No, it's all right.
miss the item, your lordship. I have to take instruction. your
Yes,
lordship.
yes.
Short date maybe.
Mr. M.K. Bora, learned counsel appearing for the petitioner, submits that the petitioner is the unmarried daughter of late. What is your father's name? Hira Bahadur Sonar. And is a resident of Haflong in the district of Dima Hasao. Stop. It is submitted that the petitioner served under
Agricultural station,
agriculture
agricultural station, lordship depot. Under Assam Agricultural University.
served under the Assam Agriculture University and was posted in Difu. Stop. Subsequently, he superannuated from service and he was granted a pension by the Treasury Officer at Haflong on 27/9/2006. Stop. The father of the petitioner, however, expired on 06/01/2021.
Yes, sir.
Stop. Pursuant thereto, since the petitioner is the unmarried daughter, she has claimed family pension. She has claimed the benefit of family pension, which has not been entertained by the authorities concerned. Para. MSR Deka Learned Standing Council, NC Hills, will obtain the required instructions in the matter. MS
S. Kemprai.
S. Kemprai appears for Karbi Anglong.
Respondent number 3.
Respondent 3. Accountant General,
1 and 6 lots. Fine.
Mr. Chakraborty for 1 and 6. And Treasury Officer? Haflong, NC Hills, okay. Director of Pension,
I mean,
Mr. Chakraborty. Let the instructions be placed before the court. Placed on the 4th of March.
May I please, Lord, sir? This case, sir, I have donated a land of 1 bigha to the construction of the veterinary first aid center at the Gojangaon at the Rupway. As per that donation of land, I have appointed as a master worker on 24/10/90.
and therefore I have continued my service on
You heard Learned Council to the parties issue notice. Returnable 4 weeks. MM Kotoki, the Standing Council appears on behalf of
1, 3, and 4.
respondents 1, 2, and 4. Who appears for 3?
Finance.
No.
uh,
You are appearing for 1, 3, and 4.
on 3 and 4.
Mr. Bor Pujari appears for respondent number 2. Since the standing councils appear for the respondents, notices are waived. However, extra copies will be furnished within 1 week from today. Respondents are permitted to complete instructions and file their necessary affidavit if so advised.
Pendency sale on the bar to the.
Pendency of the writ petition shall not be a bar to redress the claims of the petitioner. In the meantime.
Obliged.
With lordship. Well, here petitioner is my lord, his wife and the husband who is a grade 4 employee, my lord, who is on the verge of retirement this week or tomorrow, my lord. Only her grievance is very limited grievance, my lord. She is living separately with a child and not getting any information from the husband whether her name is nominee included in the pension details or not. She approves no information given. Even department, she submitted a representation that has not been entertained, my lord. That is only the information for the information, my lord.
How do you know that? Will the department know that you are the wife?
My lord, because I have already that is a Kabinnama along with us, my lord.
Where is that?
And childbirth also certificate I have annexed, my lord. Yeah.
Childbirth doesn't define, childbirth is a certificate for childbirth, not for marriage.
Yes, my lord. Here father's name is also available.
Maybe. You're definitely father and mother, but whether you're married,
I have married, my lord. Otherwise,
on what basis? The department will have, because this is the personal information.
yes.
For the department to disclose who's the nominee of an employee, they must know who you are.
My lord, he is also
Where is your legal heir certificate?
Well, then day after tomorrow, I'll take everything, my lord.
At the request of the learned counsel for the petitioner, matter be listed after 1 week. Day after tomorrow?
Yes, day after tomorrow.
Day after tomorrow, I'm not coming.
Okay. SGL lordship.
You want to have, you are welcome. I am not coming.
There's limited information for lady, my lord. That's why.
No, limited information, but how will the department find out? Mere statement will not do. You have to produce some documents.
Yes. Yes, I'll produce.
So we'll have it on. When can you produce?
It is, my lord.
Have it on 9th.
Yes,
9th of February.
Yes, my lord.
Yes, list on 9th of February. The request of the learned counsel for the petitioner. Mr. A. Bothakur appears for the respondent department forest.
PHE. PHE department.
PHE department. Okay. Yes.
Obliged.
May I please, Your Lordship? So the grievance of the petitioner is that there is difference in payment of basic pay, Lordship. Although the authority has admitted the amount, Lordship, after retirement, Lordship, he re-employed in the State Bank of India in 2006 as a bank guard. Thereafter, his service confirmed. Now, in view of the
No, service confirmed where?
service confirmed in 2007
In the bank.
in the bank, Lordship, as a bank guard.
Ah.
As a bank guard. Annexed 2. Now he retired also. Retired in the month of December 2023.
Area salary.
Lordship, kindly come to Annex 3.
Page number?
Page number 20. This is the circular issued from the Bank Authority for pay fixation of ex-service. Lordship, got it? Page 20, Annex 3. The subject is pay fixation of ex-servicemen re-employed in our bank on or after 1/1/2006. I have been appointed on 15/7/2006. And in view of this circular, Lordship, the last pay was also given from the
Last authority that Lordship will find at Annexure 4, page 22. The basic pay, Lordship kindly come to page 22, serial number 3, basic pay is 7490. So thereafter, I filed this representation, Annexure 5, page 23. Now ultimately, Annexure 6, the bank has calculated on 15 to 2019. Annexure 6, page 24. This has been calculated from the regional office and it is circulated, communicated to the branch manager, so and so, so and so. With reference to above, we forward here with the approved note regarding pay fixation of the caption employee for your kind necessary action. Then page 25, Lordship kindly come to serial number 10. Here is the difference, Lordship. Serial number 10, according to them, Lordship, in 2010, date is given 1st of July 2010. Then basic pay was 8,100. Now, Lordship, kindly come to page 33. The difference in the month of July, I should entitle for basic pay as 8,100. But they have calculated this sheet, page 33, for the month of July. Lordship, go to page 33. July basic pay is 6,450. So ultimately, the authority calculated, but till then I have not been paid the area.
No, according to you, which is the correct pay structure? Page 33 or page 25?
Page 25, Lordship.
25.
I'm supposed to get on the 1st July 2010, the basic pay as 8,100. But the bank authority has given me as 6,450. So ultimately, they calculated the amount that Annexure 7, page 26 and 27. I am given a also example for page 33. The calculated amount up to 2019 is Lordship page 27. This has been communicated by the Annexure page 26, 18/9/2019.
Okay. Where is your representation?
Representation, Lordship, first representation was in 2018 and thereafter.
Where is it? Page number?
Page 23, Annexure 5.
23.
Thereafter also I filed a Lordship.
Who's for the State Bank?
Lordship, I came to know that the notice should go, Lordship.
Okay, heard Mr. Redekar, learned counsel to the petitioner. So it is submitted that the petitioner was an ex-army personnel who was re-employed as a security guard in the SBI. Karimganj Katamani branch. On 15/7/2006, he superannuated from the services as a security guard on 31/12/2023. It is the submission of the petitioner that there is a discrepancy noticed in respect of his basic pay structure as shown by the bank for the month of July 2010.
July 2010.
2010. According to the petitioner, because of this anomaly, his financial benefits, including pensionary benefits, are affected. So the petitioner has filed representations before the authorities, but the same has not been attended to. Being agreed, the present writ petition has been filed. Issue notice returnable 4 weeks. Steps on all the respondents by registered post AD and usual course within 1 week from today. Do you want to take Dusty? Dusty is also permitted. Based after returnable date.
Get me already returned a substantial amount.
You take a Dusty, you will be listed after 4 weeks.
After 4 weeks, any day, Lord.
6th of March.
6th of March. It
will be listed on 6th of March.
Obliged.
With your lordship, possible for a time being.
No timing today. Let it come on Monday, next week. Why timing?
My senior election code number 2.
You are there. What is the matter about?
Area salary, my lord, notice made. my lord.
Area salary.
Yes.
Heard learned counsel for the parties. Issue notice. The claim of the petitioner before this court is for release of area salary. For the period he was kept under suspension. Namely, for the period 26/7/2021 to 22/12/2022, as well as for the period 1/12/2004 to 28/2/2006. Stop. Let notice be issued, returnable 4 weeks. Mr. N.J. Khatonier appears for respondents 1, 2, 3. Notices on respondents 4, 5, 6, and 7 be taken by registered post 80 at usual course. Trustee is also permitted. Extra copies be furnished to the standing council within 1 week from today. List after 4 weeks.
At 184.
Method for
Yes.
pension on the end of pensionary benefit. Kindly see, my lord, page 45, my lord. The pension proposal paper pending before the government, my lord. Page 45.
Yeah. 45.
Reason be, page 45, the additional chief engineer, my lord, is forwarded the pension paper before the government, my lord. Thereafter, no steps has been taken, my lord, and on.
Yes, Mr. Nayok.
And it is
Lordship will listen to it,
purely covered-
otherwise it appears Lordship he is entitled Lordship. Lordship
covered,
will
my lord.
issue
Can be
notice
terror, my
Lordship,
lord.
if any reasons are there, Lordship.
If he is entitled, why issue notice? You get instructions, we'll close the matter.
Like, according to the submission made by the petitioner, Lordship, somebody rejected his prayer, as his qualifying service is less than 20 years.
Already informed, my lord.
After
All right,
deducting
heard
6 years.
learned counsels for the parties, Mr. K.R. Patkiri, learned counsel for the party. Submits that the writ petitioner is aggrieved by non-release of his pension. Stop, it is submitted. The proposal for pension has already been forwarded by the Office of the Additional Chief Engineer Planning, PWD Roads. And the same is pending before the appropriate department in the government. Stop. Being aggrieved, the petitioner has approached his court. Let notice issue, returnable 4 weeks. Mr. Nayok appears for respondents number
Lordship, I am appearing for 1, 3, and 5.
1, 3, and 5. Pension and public grievance, Mr. C.S. Hazarika.
Rajiv.
Accountant General, MS so-and-so for Accountant General. Mr. Porpuzari for Finance Treasury Officer. Since all the respondents are represented by the standing councils, notices are waived. However, extra copies will be furnished within 1 week from today. And list after the returnable date.
Pendency shall not be.
Pendency shall not be a bar to resolve, to redress the grievances of the petitioner and release his pension as claimed.
Obliged.
May please, Your Lordship. Such matters regarding non-approval of the transfer of the petition. In your case, Lordship, before the online system came into force, and the process of transfer of the petitioner has already been initiated. Only the approval of the respondent of is pending. Last time.
Yes, elementary education. Elementary, Mr. P. N. Sharma was there last.
60.
Yes, sir.
Roughly.
I have received the instruction, my lord.
Oh,
Her case was not considered because she has not submitted all the documents, my lord.
yeah, she been served with a copy.
Yes, I can give the.
You go through it and find out. It is submitted by Mr. N.J. Khatoniya, Learned Standing Council, Elementary Education, that the case of the petitioner for transfer, the application, online application of the petitioner for transfer was rejected as the requisite documents necessary has not been furnished. A copy of the said rejection order has been handed over to the counsel for the petitioner. The MS J. Decca, Learned Counsel for the petitioner, prays for and is granted a week's time to complete her instructions. Matter will be listed again after 2 weeks.
Obliged.
Let's see, kindly fix a date.
23rd February.
My affidavit is ready, my lord. I'll file it today, my lord. My friend was not.
That was the prayer last.
Yes, not my friend was not
Last
on
week.
last 5 days. I'm ready with the affidavit, my lord.
Huh?
No, my friend, I could not find my friend, my lord. So I have the copy.
Oh. You furnish your email. He'll give you an online e-copy.
And I will.
Also there.
But mobile is not working, my lord. I am ready with my lord. I am like 5 it right now, my lord.
Okay, Lord.
It is submitted by Mr. S. Pora that the affidavit will be filed within what? Within?
Well, today itself.
Is be filed within this week. And he undertakes to serve a copy of the same to the counsel for the petitioner. Stop. Mr. EMS Mozumdar appears for the petition. Let the matter be listed after
Any day, my lord.
3 weeks,
No, Lordship.
2 weeks.
He has submitted them today, Lordship, then
You
On
want,
Monday.
you don't want to go through it.
Lordship. Monday, Lord.
Monday. Are you sure?
Lord.
All right, then let the matter be listed on 12th
Obliged.
February. Mr. Khatoniya appears
Yes, sir, for elementary.
for elementary education. Notice has been issued? No.
No, notice has not been issued. No, it's in the motions.
There are private respondents.
Lordship. There is one private respondent that
Then
we have to issue notice.
Private respondent is required.
Because there is specific allegation by the private respondent. There is a complaint. I have the next statement.
Notice may be issued, Lordship.
Then issue notice returnable 3 weeks. Since the learned standing councils appear, notices are waived. However, extra copies be furnished within 1 week from today. Slips on respondent number 7 by usual course and registered post within 1 week from today. List after returnable date.
Obliged.
Yeah, please, your lordship. My lord, the petitioner was placed under suspension, my lord, when he was arrested, pursuant to an
No review.
no review.
Yes, get your instruction. Heard learned counsel for the parties. Grievance of the petitioner is that pursuant to the petitioner being placed under suspension by order dated 3001/2023, as he was taken into custody in connection with BOCO PS case number 02 of 23 on 3/1/2023. The petitioner has been placed under suspension. You have been released after?
My lord,
You have been released
yes, my lord. I was
pursuant to
released on
his
7/2/2023.
pursuant to his release on bail on 7/2/2023.
My lord.
So it is submitted that as required by law, no review for continuation of the petition, for continuation of the suspension of the petitioner has taken place. There are Mr. D. Upamanyu, learned counsel for
1 and 3.
1 and 3 respondents, 1 and 3,
Higher education.
higher education. Who's for 1 and 3? Higher education will obtain instructions in the matter. List, when can you get it?
Lordship,
26th,
Milord,
26th
Milord,
February.
Milord, may I say one thing, that dependency of the petition shall not be a bar.
It is never a bar.
Oh, even then, Milord.
Tendency of the writ petition shall not be a bar for the respondent authorities to pass appropriate orders in respect of the petitioner regarding the order of suspension.
Highly obliged.
Obliged.
May I please your lordship, my lord, appropriate pending, my lord,
Time being, no timing today.
there is action also to file affidavit, my lord,
Huh?
by the respondent.
Respondents have not filed affidavit.
My lord, okay.
Who's for the respondent?
PNRD law, okay, PNRD.
Where is the PNRD department? At the request of learned counsel for the petitioner, the matter stands passed over for the day. None represents the respondents. Passed over.
Highly obliged.
May I please, Lordship? Any possible upon a matter time being, Lordship, SS Royal Lordship, another code, Lordship.
What is it about? All right, we'll pass it over for time being. Pleadings are ready. Affidavit file. All right, we'll pass it over for time being.
May it pleases your lordship.
Yes.
Lordship, in this case, respondent number 4 filed their affidavit, but others have not filed. Anyway, lordship, this petitioner, lordship, she is working in Athalsa along with 5 other people. There are total 6 people, but she has filed the petition because she was getting great pay equivalent to the Secretariat LDA as well as the High Court LDA till 6th pay commission. And thereafter, when the 7th pay commission came in, lordship, there was a distinction made and their grade pay was not increased. Unlike the grade pay of the Secretariat employees as well as the High Court employees. That is the grievance, lordship. So our case is that for equal work, equal pay should be there, lordship. In fact, lordship, I had some judgment, but because of my ill health, I couldn't go through the judgment to submit before lordship. And then the respondent have filed their affidavit. In their affidavit, their contention is that if the writ petitioner had grievance, she should have placed her grievance before anomaly committee, lordship. But then she did not even know that the salary has been changed, lordship, between the distinction is made between the parties. So that is the reason there is no, and then representations were sent to the government, lordship, and the government in the end, lordship, annexure 17, page 46. They have replied that with reference to the subject and your letter cited above, I am directed to inform you that the Finance TRU department regrets the proposal of the parity of grade pay of the employees of Asalsa with the grade pay of Assam Secretariat Service, as the proposal of parity cannot be allowed in absence of specific recommendation of 7 APPP. The pay structure of junior AA of Assam Secretariat Service is meant only for the employees who belong to the Assam Secretariat Service as recommended by 7 APPC.
Is
Lordship-
Asalsa not a necessary party here?
Lordship,
Salsa?
Asalsa, of course, we have not made because they had sent the representation on our behalf, lordship, to the government. If needed, I can add
No,
them.
it is for you to decide.
Yes, they are supporting our case because 3 of the letters with reminders and all, Member Secretary Asalsa had sent to the government, lordship. Lordship may permit me to make them a party, lordship.
What does the finance say here?
Finance lordship,
Who's for
they are
finance?
saying that um, the work of junior administrative assistants, it is different from LDA of Asalsa, whereas lordship, they do the same note taking and typing, same job lordship. There is no distinction between both the work of both the people. They do the same kind of job, and then there another thing is that the recommendation was made by the seventh Assam Pay and Productivity Pay Commission. But our case was not even presented before the seventh Assam Pay and Productivity Pay Commission lordship. They did not even know that we existed because it is only for 6 people. And then they say in page 50 on para 5 that if this is allowed lordship, it will open a Pandora's box. But lordship, here only question of 6 employees. There is no question of Pandora's box lordship. Only 6 persons are deprived of equal pay for equal work. And then their submission is that if there was any anomaly, then it should have the petitioner should have placed her grievance at page 53, place her grievance before the anomaly committee lordship. When she didn't even know that that distinction is made, and then the
What is the, why these are not referred to anomaly committees?
That's
Let the anomaly committee decide.
no, it's basically for the petitioners to approach the anomaly committee law.
How will they approach? They can approach.
Others, just like others approach law.
Huh?
Others, individuals will also approach the anomaly committee. But Lordship, my position then today will be Lordship. We have filed our affidavit. If the petitioner is not, I have not seen any reply from their side.
no, we have filed. This set. যদি লাগে মই দিব পাৰো এখন এক্সট্ৰা আছে মোৰ তাত কিন্তু আমি ফাইল কৰিছো ও মোক ক'লে মই তেতিয়া পৰা দিয়ে দিম
So far as pay scale of junior administrative assistants are concerned, Lordship, differences are there. Like junior administrative assistants in the secretariat getting different scale, and the junior administrative assistant in the district head offices, they are getting different scale. Just because the nomenclature is same, Lordship, that would not mean that they would all get the same pay scale. Lordship.
no, they started with the same year lordship. 3000 was the basic pay. Itu কোনে আমি next
Jadi annexer nege.
হয় এখন RTI কৰা reply এখন
If the pay scale is same, ordinarily, if there is a revision, then they should be given the benefit of that particular pay scale.
We hear this matter. It will take some time. I have received a copy of the reply today only.
Then we'll issue rule, let the matter come up for hearing.
fine lordship.
Heard Learned Council for issue rule. All for records.
Judicial.
Let it be listed for hearing. Record the names of other councils.
And you oblige lordship.
The proper lineage to more example of.
My lord, in this case, my lord, non-payment of this case is filed, my lord, for release of family pension, my lord. And my lord, here, my lord, school was provincialized, wherein my husband, mother worked on 2013, my lord. And he expired on 24/2/2013, my lord. And after 20 years, more than 20 years of service, my lord, as it is reflected from the copy of this, my lord, provincialized order, my lord, this date of joining. Page 20, my lord. Dinesh Sutradhar, page 20. In first,
Yes.
second, third, yes, my lord. In second, my lord, line, second box, my lord, that is Dinesh Sutradhar, in the middle, my lord, Dinesh Sutradhar is not clearly. He joined, appears to be joined 25/1/93, my lord.
Where is the name?
Dinesh Sutradhar at number one, serial number one, my lord.
Serial number 1.
Yes. Second box, my lord. At serial number 37.
Vishnu Rama ME School.
Yes, my lord. Dinesh Sutradhar.
He is the petitioner.
You know, he's the husband, my husband, my lord.
Ah.
25/1/93, he joined, my lord, appears to be joined.
Okay.
And they have filed, my lord, affidavit in opposition, my lord,
Hmm.
stating in paragraph 6 that after 2 months of my service of my husband, my lord, and provincialization order was also not issued to me, my lord.
Yes.
But as there is numbers of judgment, my lord, as he's worked more than 20 years, it can be, my lord, considered, my lord, as per long.
No, where is his original appointment order?
Yes, my lord, that is, I have annexure 2, my lord. Annexure B, page 17.
17.
Yes, my lord. This my headmaster appointment. Action taken by the managing committee of Vishnu Rama ME School filed resolution number so and so 90 in appointing Sri Dinesh Sutradhar BA to act as headmaster of the school is hereby provisionally approved with effect
This
from
is prior to provincialization.
prior to provincialization.
Then after provincialization, what happened?
After provincialization, after 2 months, after issuance of the date of provincialization order, he expired, my lord.
Huh?
After provincialization of the school, he expired 2 months thereafter. That is the, my lord, only.
When was it provincialized?
1/1/2013.
1/1.
My learned senior friend filed affidavit, my lord. He has mentioned it. Page 50, era 6, my lord.
Yes, Mr. Sutia.
Well, the school was, order of provincialization was issued on 16/5/2013. And which effect, provincialization was given effect from 1/1/2013. And he died on 24/2/2023. That is
2013.
24 February 2013. That means he served 1 month, 23 days in service. By serving 1 month, 24 days service, whether the husband of the petitioner is entitled to the pension. And after 10 months, 10 years.
Earlier service.
Now, earlier service he is not entitled. My lord, earlier he is a private school, my lord. It is the managing committee of the school appointed him, my lord. And after provincialization, it becomes my lord, her husband's service was provincialized. So after 10 years, first the petitioner is required to approach the, my lord, authority for condonation of delay of 10 years. Why she did not approve it? And she should file all the documents before the authority, then it can only be processed, my lord, for family pension. If she is entitled.
No, but if you say she's entitled, she'll file.
No, whether that will be decided by the public pension and public grievances and administrative department of government of Assam. Earlier in similar cases, direction was issued to the petitioner to approach that authority for condonation of delay under, I think, rule 243 of the pension rules like that.
Better I have to file an affidavit in reply. There are numbers of Supreme Court judgment also incorporating all those things, my lord.
So for placing judgments, you don't have to file affidavit. You can place it across the board.
Yes, my lord. Because, my lord, a reply.
If you want on facts to.
Yes, Karan Singh judgment is also there.
They have not submitted any application, my lord, who have taken the stand that they have not approached us. That for processing the, my lord, pension paper, they have to submit certain documents before the authority, my lord. Then it can only be processed and it can be sent to the director of pension like that, my lord. That has not.
All right, you place the judgments and whatever reply you want to file, you file it. Mr. H. Das, Learned Counsel for the petitioner, prays for some time to respond to the affidavit in opposition filed by the respondent authorities. Mr. J. Chutia, Learned Counsel, Standing Counsel, Karbi Anglong Autonomous District Council, appears for the council. Anyone else? Mr. P. N. Sharma for respondents 1 and 2, elementary education. MS so-and-so Learned Council appears for respondent 4. Anyone for finance? Mr. Nayak for finance. But is it treasury officer Difu will also be under you? Okay. Anyone for the headmaster? The headmaster?
No.
Yeah, we have recorded your name. Matter be listed after 3 weeks. Enabling the petitioner to file rejoinder affidavit as prayed for. List accordingly.
25 minutes.
To take instruction
That the inquiry report has been submitted. It is under consideration of the additional chief secretary. My lord, I require 10 days time to get it written. And that apart, my lords, of the record, perhaps this person has been exonerated.
It is submitted by Mr. D. Gugoi, Learned Standing Council. That was the submission last on 5/1 also.
5/1.
That was the submission on
Yes,
5/1
yes.
also.
No, my lord, it was submitted to the department secretary. It has been forwarded to the
It is
additional chief
submitted by Mr. D. Gugoi, Learned Standing Council Forest, that pursuant to the inquiry report being submitted before the disciplinary authority, matter is under consideration, and the disciplinary authority is likely to pass appropriate orders shortly. He therefore prays for 2 weeks,
10 days, madam.
2 weeks further time. Mr. L. Mohan appears for the petitioner, does not object to the prayer.
Date will be below.
List after 2 weeks.
Hold it, madam.
List on 4th of March.
Hold it.
Mr. Talukdar for account engineer.
But earlier, this service of the present petitioner was regularized, my lord, and subsequently, my lord, his regularization was cancelled. My lord, there was 3 person, namely Robin Boro under the my lord, Nolbari PWD division, my lord, roads division, and present petitioner was my lord, engaged in the Samota rural subdivision, and another Robin Boro, he was in my lord, Nolbari rural subdivision, and another and third one, he was in Dhamdhama. So, my lord, service of only out of these 3 persons, service of 2 were regularized. Earlier, they were engaged as master roll worker, my lord. Service of the 2 were regular. Lordship will directly come to the page 48, my lord. This document was obtained by the petitioner through RTI, my lord. Now they are disputing this document. This document, my lord, this was the letter, my lord, issued by my lord, Executive Engineer PWD Nolbari Rural Road Division to the my lord, Chief Engineer PWD. May I read this to the Chief Engineer? Information regarding regularization of master roll laborers engaged prior to 1/4/1993 under EEPWD Nolbari Rural Road Division Nolbari and anomaly thereof. With reference to the subject cited above, I have the honor to state that during the time of submission of proposal for regularization of master roll and workshop staff who were engaged prior to 1/4/1993, there were 3 identical names of master roll labor. That is Sri Robin Boro, son of Tumba Boro. Number 2, Robin Boro, son of Meadow Boro. And number 3, Robin Boro, son of Nobin Boro. All of them were engaged prior to 1/4/1993 and have been working under Nolbari, Samota and Dhamdhama Rural Road Subdivision respectively. That, sir, proposal of regularization of master roll services at a list of consisting 239 numbers of master roll laborers were submitted to the office of the Chief Engineer PWD Rural
Assam Sanmari Guwahati 3 for onward transmission to the government for sanctioning of post, but out of which 2 master roll labor were rejected by the government as they were engaged after 1/4/1993, and subsequently 237 numbers of posts were approved by the government by letter number so and so dated 30/9/2005. Against this division, photocopy of the same is enclosed, and accordingly, the then executive engineer had passed an order by this office, order number 132 of 2005-6 dated 7/10/2005 for regularization of master roll service whose name are included in the government approved list, and the entire government approved list were forwarded to all assistant executive engineer under the division for information and necessary action accordingly. Thereafter, the assistant executive engineer Nalbari Rural Road Subdivision took out the name of incumbent from the government approved list under his subdivision, including the name of Robin Boro, son of Tumba Boro, and prepared his monthly salary under regular cadre with effect from 22/7/2005. Similarly, the assistant executive engineer Samota Rural Road Subdivision also took out the name of incumbent from the government approved list under the subdivision, including the name of Robin Boro, son of Medoboro. This is the present petitioner, and prepared his monthly salary under regular cadre with effect from 22/7/2005. In the meantime, 22 numbers of master roll laborer, including Sri Robin Boro, son of Nobin Boro, who was working under Dhamdhama Rural Road Subdivision, were transferred to the newly created Nalbari State Road Division before receipt of government approval list. The service of Sri Robin Boro, son of Nobin Boro, has been regularized against serial number 157 of government approved list of 237 numbers of posts. Since then, his salary has been paid under regular cadre State Road Division with effect from 22/7/2005. In the meantime, Sri Robin Boro, son of Tumba Boro, who was working under Nalbari Rural Road Subdivision, expired on 9/12/2011. Hence, at the time of submission of proposal for annual retention for 2012-2013, the division remarked against Robin Boro as expired, for which name of Robin Boro was deleted from the list of annual retention received from the government. On deletion of the name of Robin Boro from the annual retention list 2012 and 13, no more Robin Boro was in existence in the list of annual retention, but another Robin Boro working at Samota Rural Subdivision, continuing his salary as usual, the present petitioner. The anomalies were later detected in the time of submission of proposal of annual retention for 2013-14 of government. On detection of these anomalies, the whole matter was scrutinized and found that the practice of enjoying salary, etc. by one Robin Boro still continuing without any annual retention, as well as when the matter come to the undersigned, being the executive engineer, had started an inquiry to trace out the real fact, and after inquiry, the matter thoroughly, it is found that number one, though the 3 numbers of Robin Boro were engaged prior to 1/4/1993, the name of Robin Boro, son of Tumba Boro, working under Nalbari Rural Subdivision, was not included in the list of proposal for regularization, but only 2 numbers. That is Sri Robin Boro, son of Meadow Boro, the present petitioner, and Robin Boro, Sri son of Nobin Boro, who has been working under Samota and Dhamdhama Rural Road Subdivision, were included in the list of proposal for regularization submitted earlier from this end. Accordingly, government has approved only two names of Robin Boro against serial number 63 and 157 in the government approved list. But service of Sri Robin Boro, son of Tumba Boro, working under Rural Road Subdivision, was also regularized against serial number 63 is missing, 63 of government approved through oversight by the executive engineer. Perhaps the mistake was done due to identical name. On the scrutiny of annual retention, it is seen that this division received annual retention for the year 2006-07 in respect of 237 numbers of regular master roll master roll labor grade 4, which included 22 numbers of master roll in respect of Nalbari PWD road division also. But the annual retention for the year 2007-8 up to 2011-12, this division has received a list of 215 regular master roll labor grade 4 in respect of Robin Borough. One Robin Borough was included in 215 master roll labor. In this regard, it may be stated that the concerned executive engineer as well as the concerned staff also unaware in the matter and could not detect the mistake happened at the time on the grounded that Robin Borough was working in different subdivision. So existence of two Robin Borough against one sanctioned post was not come to the knowledge at the concerned authority. Even the treasury could not detect the instant case till then. However, the mistake has been continued unknowingly from the time of regularization up to the submission of proposal for annual retention for 2013-14. And after proper verification, it is found that the service of Sri Robin Borough, son of Meadow Borough, has been working under the Samota Rural Road Subdivision, whose service has been regularized against the serial number 63 of government approved list, which is genuine. An annual retention was also received from the government against his name up to 2011 and 12. This is the present petitioner. But his name has been deleted from the retention list wrongly when Robin Borough expired on 9/12/2011, whose service was not regularized by the government against serial number 63 of the government approved list. So the matter is therefore placed at disposal of your honor for a suitable solution of the following issues at the same was not intentional from the side of the concerned officer and staff of the division to arrange ex post facto approval for regularization of service of late Robin Borough posthumously, who was engaged prior to 1493, and instruction regarding preparation, submission of family pension papers. To revive the annual retention with effect from 2012-13 up to 2013-14 in respect of Robin Borough, whose service has been regularized against serial number 63 of the government approved list and has been serving at Samota PWD Rural Road Subdivision. The son of the petitioner submitted an RTI application in the year 2021. Then this document was provided to him. Now they are disputing this document.
Where are they disputing it?
My lord?
Where are they disputing it?
My lord, they have filed their affidavit, my lord. Affidavit, lordship will find para 9 onwards.
There are 9.
In fact, 6 also they have stated, my lord. Where it's paragraph 6, my lord.
6, okay. Yes.
That as regards the statements made in paragraph 4 of the writ petition, the deponent humbly begs to state that the averment makes it paragraph 4 of the plaintiff, that the defendant begs to state that during the time of submission of proposal for regularization of master roll labor, there are 3 identical names, master roll laborers: Robin Borough, son of Tumba Borough. His date of joining was on 11/9/87. Robin Borough, son of Matiram Borough, joining date 11/3/1987. And son of Robin Borough, son of Nobin Borough, is joining date as month. All of them were engaged under 3 different subdivisions within the jurisdiction of respondent number 3, that is Nalbari, Samota, and Dhamdama. In this regard, it is stated that for regularization of service of master roll laborers number so and so, a post were approved by the government dated 30/9/2005 against the division, and accordingly, service of 237 numbers of master roll laborers were brought to the regular cadre in scale of pay so and so to rupees so and so. But in the said approved list, master roll labor, the name of the petitioner husband was not included for regularization of his service. In the said list, serial number 63, another Robin Borough, whose father's name was Tumba Borough, his joining date was 1/9/1987.
This is filed by whom? Affidavit?
My lord, this affidavit has been filed by PWD, my lord. Respondent number 2.
Chief Engineer.
Yes, my lord.
And the earlier communication was issued by executive.
Last date, your lordship directed me to obtain the relevant record, lordship, reflecting all these facts. I think that record is not with me. So let that record come, lordship.
We have already filed our reply.
Reply is there.
After 9 years, how can they, my lord, now dispute this document? This is the RTI document, my lord. What actions they have taken against that hearing officer if this document is false, my lord?
No, there is no question of disputing or agreeing, Lordship. It's a Lordship will see the prayer, your Lordship is himself is praying for regularization, Lord.
All right, in terms of the earlier order dated 12/1/2024, the records, relevant records, on the basis of which the communication dated 19/9/2014 issued by the Assistant Executive Engineer PWD Somota Rural Road Subdivision Somota were directed to be produced. Mr. P. Nayak, Standing Council PWD, prays for further time as the records are not available. As the records have not been made available by the department. Mr. N.K. Kolita, Learned Counsel for the petitioner submits that the pleadings are completed. The matter needs to be heard as it is a question of release of family pension. As it is a claim of the petitioner for family pension in respect
And
of
area salary.
an area salary. Let the matter be listed on 20 February 20.
Lord.
The records as directed be produced for perusal of the court if required.
Obliged.
May I please, Lordship? Actually, earlier, Lordship, Honorable for Direction, Lordship, I filed an additional affidavit. It's in the record, Lordship.
Why, what additional affidavit?
According to Lordship, their claim is that, Lordship, we are not government employees. But we are government employees. Our parent department is soil conservation, Lordship. Soil conservation department.
Pleadings are complete.
My lord, we have not,
Soil conservation has filed affidavit.
yes, my lord, we had filed, my lord, on 2/12/2022, my lord, but we had not been served, my lord, that additional affidavit.
You serve that copy.
Right, sorry.
It is submitted that pleadings are completed and Stop Learned Counsel for the petitioner also submits that an additional affidavit has been filed on. When did you file it?
Eighteenth of July, Lord, 2023.
18th of July.
18th July, 2023. I see.
By the petitioner, additional affidavit. Learned Counsel appearing for the Soil Conservation Department submits that the affidavit, copies of the additional affidavit has not been furnished. Counsel to the petitioner to furnish a copy. Since the pleadings are complete, matter be listed for hearing.
It is short date May fixed. Lord.
What is that IA for?
I, Lordship, that copy was not, I did not receive that copy, Lordship. They have filed it.
I no, my lord, that I has been filed my petitioner, my lord.
No, I have not filed.
No, earlier council.
Earlier, maybe Lordship,
Earlier
I am
counsel.
newly engaged counsel, Lordship. But that copy was not with me, Lordship.
You are not pressing the IA.
No, Lordship, I am present, Lordship. Earlier, another council is there, Lordship. I see to go here, Lordship.
Whatever it may be, there's an IA. Are you pressing or not pressing the IA?
I'm pressing, Lordship.
You're pressing.
Pressing, Lordship.
Yes.
But I did not receive that copy, Lordship.
Huh?
I did not receive that copy. from
If you
him,
can't
Lordship.
receive, then if you have not received, then how will you press it?
I collected, Lordship. I collected the copy, Lordship.
Matter be listed for admission hearing on on
First week of March, Lordship.
12th of March. 12th of March.
Today I will check out. I'll check today.
No, if the affidavit is filed by the finance department till date, Lord.
I have received the instruction, my lord. A proposal was received from the irrigation department. My lord, that was returned to the irrigation department. That was returned to the irrigation department, my lord, with all the checklist of queries, my lord, because that proposal was not complete. Now, my lord, the further proposal is not forthcoming, my lord, from the irrigation department. That's why, my lord, the finance department has communicated with the irrigation department to submit an action taken report.
So only.
সব কিছু তো আপনার হোয়াটসঅ্যাপে পাঠিয়ে দিন অন্য কোনো লোকে দিতে হবে
What is this? This is only forwarding a copy sent by the standing council.
Yes, madam.
Huh? No, the copy which you have just handed over,
My lord.
it is forwarding a copy
So prior
from
to
under secretary to deputy secretary.
Yes, my lord, it is my lord with regard to my lord. After passing of my lord subsequent order by this honorable court, my lord, in this writ petition.
Huh.
Because the earlier bunch of instructions were placed before this honorable, also will kindly see this. So this is the link, my lord, between the two instructions, my lord.
No, what is your submission? You are praying for time.
My lord, the irrigation department has not submitted, my lord, the fresh proposal. Also will kindly see, my lord, the earlier instructions. Details of the employee concerned, my lord, that is the petitioner herein, my lord, shall have to be, my lord, furnished by the irrigation department. And my lord, a proposal was sent to the finance department.
Yes, irrigation, who's appearing for irrigation? Anyone for irrigation department? Karbi Anglo.
My lord, as per order passed by the honorable court on 4th August, the matter was placed before the finance department by the irrigation department.
That was, my lord, resent to the irrigation department,
So-
which is apparent on the basis of the.
Which order you are referring to?
4/8/2023.
4/8.
4/8.
Yes.
So the role of the irrigation department perhaps ended.
So then subsequently it has been returned back. Then apparently that has not been submitted. Who's for irrigation department?
Yes, my lord, it is with the. Because that
Who's
is
for the
irrigation
irrigation?
Department.
Chief engineer irrigation. Who's there? Is there a standing council? You are appearing for irrigation. Chief engineer irrigation. You have to use the microphone, madam. I can't hear you. 3N? No, you are appearing for 3 and 6. Who's appearing for 4?
Earlier, DS Nevu was appearing, lordship.
Perhaps, my lord, now the instructions has to be furnished, my lord, by R1. That is the government, my lord. It is now in the intra-government, my lord, communications are going on. Yeah, unless and until, my lord, the full particulars are not placed before the finance department as per the query list, my lord. The department is not in a position to take a decision.
What is that serial number 8? You have a copy?
No, my lord, I had only one copy, my lord. Because, my lord, the views of judicial department has also been sought for.
What is the final order of the High Court? What order is sought? What order is sought for?
My lord, that writ appeal, my lord, 45 of 2014, my lord.
That is available with finance.
That is available, but that should accompany with all the, my lord, other queries list, my lord. Because they will have to, my lord.
Yeah, who's for the finance department, Mr. Chakraborty? Sorry, irrigation department?
Irrigation department and Upadhyay is the secretary council,
So please call him.
my lord.
Call him, call him. Yes, after a while. Happy? Please go.
Finally, finish the last one.
Lordship, I have received instruction, Lordship.
Hmm.
We have found something, 4 shortcomings, Lordship. We have issued a letter to the department as well as copies to the petitioner, Lordship. I'll furnish him in the, today, Lordship itself, Lordship. We have found 5 shortcomings, Lordship. The form has to be duly countersigned by the head of the department. Then she has to furnish a non-marriage and non-employment certificate as mandated under the Pension and Public Grievance Department notification dated 9/8/19 and the indemnity bond and an affidavit. If she furnish, I
You have sent all this to whom?
to the head of to the administrative department with a copy to the petitioner also.
Home Department.
Yes.
I will furnish a copy to my friend. Lordship. Let it come after. I think to overcome these difficulties, some certain time will be required, Lordship. Let it come after 4 weeks, Lordship.
I have not received any letter, my.
Do you have an extra copy? You furnish it.
Just I have received government device. I will furnish to my friend, Lordship.
No. What is that? What is the date of the communication you have received?
31/2024.
31.
31.
30.
What effect?
Lordship, this has been sent to the Home Department, Deputy Secretary, Home A Department.
Hmm. This is a communication dated 5/8/2023.
No, I have received today only, Lordship. Just now on
You
my-
have received today. This is sent by principal accountant. No, sorry, it was sent by deputy secretary.
Government to the AG, perhaps, Lordship.
Government to the AG.
Lordship, now AG has written back to the department, pointing out certain shortcomings, Lordship.
What are the shortcomings?
Lordship, that is, that form has to be duly countersigned by the head of the department. Then she has to furnish a certificate of non-marriage and non-employment. Third is an indemnity bond. She has to furnish an indemnity bond. Fourth is an affidavit that there is no disabled child. And the fifth.
On what basis you are asking for these documents?
These all are mandated under the Pension and Public Grievance notification dated 9/8/18.
Bring it on record.
Lordship,
Show us.
let it come, Lordship, on Wednesday next.
Who's for the administrative department?
Home Department.
You are representing, you have not communicated to the petitioner?
No, it has been dispatched on 30 only, this 30 of January.
It is submitted by Mr. B. Chakraborty, Learned Accountant General, that certain communications have been issued by the Accountant General to the administrative department, namely the Home Department, Government of Assam, requiring certain documents to be furnished by the department / by the claimant of family pension, namely the writ petitioner. Stop. Upon receipt of these documents, it is submitted that upon receipt of the documents, the process for steps for processing the pension, family pension in favor of the petitioner will be undertaken. Stop. Mr. Patieri, learned counsel for the petitioner, however, submits that he has not received any communication as to the furnishing, as to the requirement of any documents to be furnished by the petitioner. Mr. B. Chakraborty and Mr. C. S. Hazorika, learned standing counsels, learned counsels representing Accountant General and the Home Department, submits that matter be posted after 2 weeks. And in the meantime, they will update, and on the next date, they will update the court as to the steps undertaken by the respective departments towards the claim of the writ petitioner. List on 26th February.
Offline.
May it please your lordship. Lordship, the matter pertains to payment of full pension, my lord. My lord, the petitioner joined as a Gaon Panchayat secretary on 1st of May 1968 under Jorhat Zila Borikhat, my lord, and retired on my lord 30th of November 2003, my lord. My lord, the law has been laid down in Fazle Rabbi, my lord, the division bench order of this honorable court. My lord, it has been clearly recorded, my lord, directed by this honorable court, my lord, in page number 53, my lord. We are therefore of the considered view that the benefit of the provisions of the Act, including those for pension and other retirement dues, would be available to the provincialized employees in service on and after 1st of October 1991 on the basis of the length of their service reckoned from the date of their initial appointments, my lord. And my lord, the petitioner herein was a part of that writ appeal, my lord, in serial number 133, my lord, in Fazle Rabbi, my lord. And my lord, after that, my lord, PPO was, my lord, issued, my lord, whereby in lordship may be pleased to come to page number 59, my lord.
Yes.
My lord, it has been, my lord, in the PPO, my lord, it has been stated that non-qualifying service 17 years, 0 months, 29 days, my lord, which is contrary to the division bench order, my lord, because it has been clearly stated it is the initial date of appointment, my lord. And the initial date of appointment is 1964, my lord. And which would be, my lord, 39 years, a few months, my lord. My lord, it is clearly in violation of that law, of that judgment, my lord. And my lord, petitioner had filed another writ petition stating that full pension has not been granted to him, my lord. Lordship may be pleased to come to page number 69, where an observation was made by this honorable court, my lord. My lord, where the petitioner would be entitled to full pension along with arrears, my lord. But till now, my lord, the petitioner has not been granted full pension, my lord. This has been granted only 1,712 rupees, my lord, instead of 2,540 rupees, my lord.
Yes.
Now, the entire issue, my lord, revolves around this date of initial appointment. Now, this date of initial appointment is a question that has been left open by the Fazle Rabbi judgment. Date of initial
Show us from the judgment that it is left open.
Page 53, my lord, the last line, which I don't know if I just read. Page 53. The last 5 lines, my lord.
53.
Page 53.
Yes.
We are therefore of the considered view, last 5 lines. We are therefore of the considered view that the benefit of the provisions of the Act, including those for pension and other retirement dues, would be available to the provincialized employees in service on and after 1/10/1991 on the basis of the length of their service reckoned from the dates of their initial appointments. My lord, on a bare perusal of Rule 31 and 36 of the pension rules, The appointment has to be on a substantive post in a permanent establishment. The question is, when was he substantively appointed against the sanction? Is the question. From that day onward, the qualifying service would commence. The date of initial appointment is something that needs to be looked at.
Come to page 52. Somewhere towards the middle, you'll find whereas it is obvious. Do you find it?
Where is it?
Page 52 in the middle,
Yes, my lord,
whereas it is obvious. Please read on.
Whereas it is obvious from section 4(2) of the Act that eligibility of the provincialized employees thereunder for pension or gratuity or both would have to be adjusted in accordance with the pension rules applicable to the government employees of equivalent rank. According to us, the key to the proposal lies in the definition date of appointment, which indicates unerringly to be one vis-a-vis such employees, the date on he or she had joined the service of the panchayat. In contradistinction, appointed date joined the service of the.
That's it. Date of appointment is the date of joining the service.
My lord, page 51, the last line.
Page?
51.
Hmm.
Last line. Definition of employees. Provincialized employees.
Hmm.
Employees. Employees means a person in the employment of panchayats against a regularly sanctioned post.
Hmm.
So when he was appointed against, as in when he or she gets appointed against a regularly sanctioned post, from that day onwards, my lord, he or she becomes an employee.
Where is the order of regularization? Is it here?
They've not annexed.
My lord, it was submitted to the department at the time of retirement, my lord, but in the pension payment order, my lord, it has been reflected the date of appointment is as 1st of May 1964, my lord.
No, that is your original appointment.
Yes, my lord.
Then
And
subsequently you are regularized.
yeah, my lord, there was no regulation because, my lord, the person, my lord, the petitioner was provincialized as on 1991, my lord.
Provincialized. Huh.
And my lord, if we subtract, my lord, 17 years, then my lord, it doesn't come to 1991, my lord. This,
They get a proportionate pension, my lord, from the date they were given the regular pay scale.
my lord, a right was already accrued to the petitioner, my lord, when this judgment firstly
Oh,
was.
you will have to consider it from the date they were provincialized. That's what the judgment says. Eligibility of provincialized employees.
But my lord, Rule 36, if my lord would see, talks about like when he is in a substantive post in a permanent establishment. So we have to see when he was regularized or provincialized against a sanction.
You show us the regularization order.
That I'll have to procure.
You show us if there is a regularization order.
When he or she was appointed against a sanction.
No. They were appointed initially against some post.
They were casual laborers, my lord. Fixed.
Whatever it may be. Subsequently, it was provincialized, isn't it?
Yes, my but my lord, date of initial appointment is to be, my lord, considered, my lord.
That's
And
right.
yes,
Their
my lord.
question is initial appointment was made against a non-sanctioned post.
My lord, but my lord, similarly situated people, my lord, they have been granted full pension, my lord. There have been numerous judgments of this honorable court, my lord.
But the doctrine of estoppel doesn't stop us, my lord. We can always challenge.
But my lord, no,
Do you have a copy of a similar judgment here?
Yes, my lord.
But there in these issues were not taken up.
My lord, many.
This is an order passed by this bench.
But may always differ. In fact, my lord, Fazli Rabbi's judgment, my lord would see if Fazli Rabbi's judgment has not taken into consideration these issues, my lord. Rule 31, Rule 36.
You go and
the
urge before the
definition of
division
employee.
bench.
My lord can always.
You
refer
go
it.
and urge before the division bench. You go and appeal. Your appeal was dismissed before the Supreme Court.
My lord, in limine, so the question of law still, it was simpliciter dismissal, my lord. The question of law still is open.
Your arguments will have to be directed towards the law points, and if you want this matter to be referred to a larger bench, specific arguments to that effect will have to be made. You can't try to distinguish a division bench judgment merely by picking up some words or some lines from some paragraphs.
But the,
If your contention is that the question whether it was required to be in a substantive post or not has never been decided, you urge it properly. You've not done it. We've passed orders. There are other benches passing orders.
my lord always
You
has
have
the,
not filed appeals against those or review.
my lord always has the power to refer it to keep it.
We have the power to do, but we
Because, my lord,
want
the
the
basic
department to
question
be
is-
concerned, and if you are concerned, you should take whatever steps.
Because the question of date of initial appointment is so
Heard.
vague and so open-ended.
Whether councils disposed. Yes. Names of all councils be recorded. Yes. अरे टाइमिंग बाद में आएगा, पहले इसको कंटिन्यू करो ना. टाइमिंग बीच में क्यों बुलाते हो आप लोग? एक सीक्वेंस में काम करो ना. There's a sequence, there's a cause base. तो पूछ लीजिए करो आप. कौन बोला आपको टाइमिंग देने के लिए? कौन? कौन वो? ये कोर्ट मास्टर है कि वो आप है? Yes.
May it please the Lord, sir. Lord, in these two cases, my lord, the petitioners were, my lord, initially appointed, my lord, by the authority, my lord, as. Lordship. That's fine, my lord.
Arrear salary.
My lord.
In both the matters, we have received instructions, Lordship. May I pray for 2 weeks time to file our affidavit? Lordship? We have received the instruction, Lordship.
Please file it.
Lordship.
Yes. Let him file the affidavit if the instructions are available.
Lordship.
Mr. R.M. Das, learned counsel appearing for
Social
the
justice and empowerment.
for
Social
justice and empowerment. Submits that instructions have been received and you'd like to file an affidavit in the matter. Mr. I.H. Soikia, learned counsel for the petitioner, does not object to the prayer. List after 2 weeks.
Our name may be shown, Lordship.
Names of all standing counsel to be reflected. Based on 28th February.
My lord.
Yes.
My lord, as per instruction, my lord, area proposal for almost ready, my lord, but some document required from the petitioner, my lord.
So what some documents have you communicated to the
Already
petitioner?
send letter to petitioner,
When? Which letter?
on 24 January.
Has he received it?
No, no,
He's not received
I
it.
have received nothing. Whatever is to be legal, it is their duty to place a affidavit through that. I was required to know.
So these kind of
Simply
vague
some document
instructions will
sent.
not do.
That will be lingering.
You are making, see, have you seen the last order?
Yes, my lord.
Then
That instruction I have.
what instructions? What documents are necessary? What documents are necessary?
My lord.
That additional affidavit, the figures are clearly written. That is 61 and 62.
Additional affidavit.
There is, matter has been more clearly indicated against the name of the teacher, the school, and the period and the amount. That is 61 and 62.
Yes. They are all the petitioners.
Oh, yes.
They are the petitioners.
Yes. 6, 7 years past, 10,000, some was 14,000, 18,000, 50,000. That one, some of these kept detailed till today.
Just show him the instruction. Share your instruction. The counsel for the petitioner. There are some documents necessary from you as per the report of the DEO. We can issue a direction and close your petition.
Yes.
Specific direction.
Yes.
Time bound. If you want. Heard, learned counsel for the parties. Yes, Mr. Mehdi?
As per the, I will see now. Now I've not gone, so I will see what is written here.
Okay.
Short that may please be
All right.
important.
Heard learned counsel for the parties. It is submitted by the learned standing council that the pension, the proposal for area salary in respect of the petitioners have been sought for from the DEO.
Yes.
Kamrup. And it has been informed by the office of the DEO to the Director Elementary Education that certain documents are necessary from the petitioner which have been sought for but not received. Copy of this communication has also been placed before the court. Mr. Mehdi, learned counsel for the petitioner, submits that you'd like to complete his instructions from the petitioners in respect of these documents sought for. He prays that the matter be listed after 2 weeks. List again on 28th, 28 February. Yes, Mr. Bush. So,
Well, not here, well, not till date, they have not filed any response to our petition, well. Well, not
affidavit, you,
Affidavit was to be filed as per last order by the finance department. They have in certain position manner. The finance department may file their affidavit before a next returnable date, especially on the issue as to how different view can be taken in respect of present petitioner. When there is already a judicial view taken in, there is exist a policy of 20th April 1995 for regulation of the master rule workers who were appointed prior to 1/4/1983. We are clarifying that the required affidavit of the finance department in respect of the present petitioner and not the general.
the date may be fixed, my lord, and let them file the affidavit as last transfer.
yes, Mr. Borpuzari. Names not shown. At the request of the Standing Council, Finance Department, matter stands adjourned for 2 weeks, enabling them to file the affidavit as in deference to the order of this court dated 2/1/2023. Mr. G. Bosho, learned counsel for the petitioner, appears for the petitioner.
Fine.
Mr. T.C. Sutia appears for state.
Yes, sir.
State. List after 2 weeks.
Problem.
4th of March,
Mine.
listed on 4th of March.
Yes. Yes.
Make clear. My lord, in this lordship, the education department have last occasion take time for inspection lordship regarding
Elementary.
lordship.
Yes, who's for elementary department, elementary education? Do you have instructions here?
Provisional pension. Provisional pension. Component. No. Provisional pension is there. Area salary, gratuity will be there.
PPO issued.
Yes, madam. As per instruction.
PPO has been issued.
Lordship, only that letter was issued lordship, but regarding other part lordship, area salary, as gratuity, nothing that they have paid lordship. Only that letter provisional.
No, pursuant to this, has it been communicated to the petitioner? Has she received the
Lordship,
PPO?
That copy received, lordship.
She has received the PPO.
That instruction I need to.
You
be
get
done.
your instructions there.
But regarding other part also, lordship.
Other, first you get whatever is offered to you, take
Lordship.
it. Then we'll decide whether other part required, not required. Mr. Pegu, learned counsel for the elementary.
Elementary.
Huh?
Elementary.
Elementary education. Has placed before the court a communication issued by the Director of Pension, the Treasury Officer, forwarding the copy of the PPO number so and so in favor of the petitioner, namely Anwara Khatun, wife of late Siddiq Hussain. Stop. It is submitted that pursuant to this communication, the petitioner is required to appear before the concerned Treasury Officer and receive her share of pension along with the copy of the PPO. Stop. Mr. K. Mazumdar, learned senior counsel appearing for the petitioner, submits that he would like to complete the instructions in this regard. Matter be listed after 3 weeks.
Lordship.
May I will not. Lordship, as per the last order, Lordship, the finance department is to apprise this honorable court regarding the decision on the pending proposal, Lordship.
Yes, order dated 12/1.
Lordship.
We are awaiting the updated instructions, my lord. My lord, what has happened in this case, my lord, post tenders, my lord, the government took a policy decision, my lord, that all the administrative departments will provide a list of their, my lord, employees who are entitled. Now, my lord, here is a case where, my lord, 3 departments, PNRD,
Hill Area Department and my lord Irrigation Department. My lord, after that exercise was my lord complete, my lord, they are again sending persons. The names of my lord eligible persons without giving any proper checklist. So that is why my lord the matter is tagging around, my lord. Possible kindly grant me, my lord, further 2 weeks time, my lord. I am awaiting the instructions, my lord. Updated instructions, my lord.
My lord, in fact, the petitioners are entitled, the department send this proposal, lordship, kindly peruse the order of this honorable chief 19/5/2020. There is a specific direction, lordship,
Order dated?
19/5/2023, lordship.
Yes.
Lordship, by this order, lordship, the honorable court, lordship, paragraph 6, lordship. In view of the above directions so passed by the division bench, this court finds that no liberty is given to the finance department not to grant the benefits to the minimum of scale of pay to those persons who are covered within the ambit of paragraph number 22 of the state judgment. It further appears that the PNRD department, while sending the details of the petitioner along with others, has categorically mentioned that the date of engagement of the petitioner was on so and his length of service is still was 12 years. Under such circumstances, this court further gives another chance to the finance department to do the needful. Then, lordship, they have not done anything till date, lordship.
Yeah, Mr. Borpuzari, I think
No, my lord, he is correct, but difficulty is that my lord, lordship may be pleased to come to page 16 of the writ petition. What is that? He is mixing up everything, my lord. That is the difficulty.
Huh?
His petitioner is mixing up his reliefs, my lord. He is not seeking a specific relief. His relief is defined, my lord. The relief sought for page 16, my lord. Kindly see, my lord. Page 16 of the writ petition, that is the prayer portion, my lord.
Hmm.
My lord, the first prayer A, my lord, direct command to the respondent authorities to provide payment of minimum pay scale, my lord, fine up to here. To the petitioner as junior assistant LDA. This is a defined post, my lord. This is not contemplated as a MR or casual worker, my lord. So he ought to have made, my lord, a very clear statement, my lord.
whatever he is entitled. You give him.
No, my lord, he is entitled.
His prayer may be for anything, but as per the department, at least you say that he's entitled to this
Yes.
scale of this pay and release it.
Yes.
B is their lordship, B is their, the respondents, more particularly the respondent to accord approval on the proposal sent by the Panchayat and Rural Development.
Merely because he has made a wrong claim, his rightful claim cannot be denied.
My lord, we have communicated to the department, my lord.
Which department?
My lord, the finance department, we have communicated. We have received some instruction, my lord, but those instructions are not complete, my lord.
You point out this May order.
Yes, yes, yes. It is there, my lord. It is there in my file also, my lord.
If it is there, then you have already been given a last opportunity.
Yes.
Then
Will kindly grant me some time, my lord. Otherwise, lordship will dispose, my lord. Because there are earlier round of litigation whereby, my lord, the petitioner is entitled, my lord. That I cannot defer, my lord.
then we dispose it of.
Okay. Give a specific time, lord.
Had disposed of in terms of the order. You consider the claims within a period of 90 days from the date of receipt of a certificate copy and so on.
Lordship may be pleased to direct both the PNID as well as the finance.
No, lordship, PND already has done that.
Whatever will direct the respondents. Yes.
If the proposal is shortcoming, he will be.
There are 2 writ petitions. Is it connected?
Lordship, in item number 38, lordship, there is a direction because I have already filed. This is my second writ petition. Earlier I have filed, and when there was a direction to consider his claim. When the claim was not considered as per the order of this order court, I have filed contempt, and the order page 52, lordship, contempt case, lordship. Page 50, look kindly peruse. Where the
52 in which writ petition?
38, lordship.
Why can't you give us the number of the writ petition?
Lordship.
Writ petition number?
1301.
1301, yes.
Page 52, lordship.
1301.
Lordship.
Yes.
Page 52.
Yes.
Mr. Lordship. and a counsel appearing for sole respondent who submits that in terms of the order dated 29/7, the respondent has done his part and the matter was sent to the finance department seeking necessary approval. However, the finance department has not accorded the approval, as a result of which the matter could not be proceed further. Mr. Nas submits that there is no willful violation of the court's order by his client. From a scrutiny of the materials available on record, I find that the finance department was not a party in the writ petition, and therefore it is apparent that there was no direction upon the finance department to deal with the matter in any particular manner. There is no dispute about the fact that the respondent has carried out his part on it in terms
All
of
right,
the
so thereafter you have filed this petition.
this petition, Lordship.
Now, we were not asking about this petition, we are asking about 359. 359 is what?
Lordship, non-payment of fixed remuneration, Lordship.
Similar matter, similar issues. PNRD.
Lordship, may be pleased to direct, my lord, both the PNRD
We'll do
department,
that.
finance, or let the administrative department, my lord, make all necessary verification, my lord, with regard to their initial appointment and all other.
All right, all right.
But as far as the study department is concerned, on a way back in 2021, there was a list of 1,080 casual workers, which included the name of both the workers have been it was the bank department.
Very well, you do it again if required. Dispose.
My lord.
Yes.
Apply.
Apply.
My lord, item number 22.
That the joint request matter stands passed over for the day.
No.
29.
Yes.
He was the one earlier, okay. The reporter was there some time ago.
That matter, my lord, where the proposal is pending with irrigation department. Lordship has sought for their presence.
And he came, but accordingly went away.
It is submitted by Mr. R. Borpuzari, Learned Standing Counsel Finance, that the matter has been referred back, returned back, remitted back to the what department? Irrigation department,
My lord.
with for requesting for resubmission of the proposal after further examination of the queries raised in the communication dated 26th of December 2023. So, copy of the said communication is placed before the court, which is kept as a part of the case record. However, in the absence of the standing counsel for the irrigation department, the matter is required to be deferred to another date, enabling the irrigation department to obtain. Yes, irrigation, what have you done?
In fact, but in this case, my colleague,
Who is your colleague?
Yes,
You inform him.
Lord, I tried to call her, also I did not contact.
Then we'll record your name.
Lord,
Mr. N. Upadhyay appears for the irrigation department, who will obtain the required instructions on the communication dated so and so, and place before the court as to the status of resubmission of the proposal of pension,
Yes.
pension proposal
Yes.
of the writ petitioner. Mr. Muttaki, Learned Counsel, appears for the petitioner. Placed again after 2 weeks. Matter will be listed again on 28th of February.
28th of February.
28th of February.
My lord.
You furnish him a copy
Yes, yes, my
for
lord.
enabling him. Names of all the respective respondent councils be reflected in the cause list by the registry.
May I please?
Yes.
My lord, in this case, my lord, in the second round of litigation,
already this honorable court, my lord, by the order dated 21/9/2022, page number 46, has directed the authorities, my lord, to consider the benefit of grant of benefit of MSCPS. And what happened, my lord, by the impugn order, while considering the claim, my lord, they have rejected on the same ground which has been already considered by this honorable court while deciding the earlier case matter. Stating that there is a pending criminal case is pending, therefore his
Where
benefit
is
cannot be
that
considered.
order?
Lordship,
Where is that order?
earlier order. Earlier order, my lord, page 46. It starts
No, the order of
impugn
the.
order. Impugn order, my lord, is at page 54. Operative portion, page 55, last paragraph.
Yes.
Already, my lord, these aspects have been discussed in the earlier judgment matter. What happened, this is the office memorandum 14/8/2018. This office memorandum at page 42. At
Yes.
page 42 it is there, type copy. This office memorandum has been issued on the strength of the another notification, that is 17 March 2017, that is ROP. ROP, 7th ROP notification, 17th March 2017. This is 309 rule, my lord. Under this ROP scheme, my lord, ROP scheme has been enumerated, discussed in the earlier writ petition while passing the judgment, my lord. Paragraph 6 onwards, it starts from page 49, which says, even if, my lord, cases are pending, that in that event, my lord, provisionally MSCPS benefit can be given, subject to recovery if any. That is there, page 49, clause 5B7. It is quoted clearly, my lord.
What was the ultimate direction by the court?
Direction, my lord, page 54, it starts from. In the light of the above discussion, this court is of the considered view that the case of the petitioner may be considered for grant of financial benefit provisionally by the competent authority by taking into consideration the provisions of the MSCPS, more particularly clause 5B14 and the office memorandum dated 14/8/2018 together. Accordingly, this writ petition is disposed of with a direction to the state respondent authorities to consider the case of the petitioner for extending the financial benefit provisionally in terms of the MSCPS and the office memorandum dated 2018 by taking into account that the petitioner's more than 20 years of service in the SES is without regular promotion. After such consideration, a speaking order be passed, it is ordered accordingly. It is further observed that such speaking order is to be passed within a period of such a period.
What is that memorandum 14/8?
My lord, 14/8 is the memorandum issued by the government of Assam for regulating the benefit of MSCPS in respect of the LCS cadre. This is on the basis of the ROP notification. An ROP notification, which is the, my lord, 309 rule, my lord, it prescribes that in the event there is criminal proceedings against anyone, my lord, then it will be provisional and the grant will be provisional. Therefore, incorporation of the impugn clause in the office memorandum itself is not, my lord, justified. That depending.
No, where does it say provisional? Does it say-
Provisionally, your lordship will find it is quoted in the judgment, my lord, page 49.
No, in the office memorandum.
Office memorandum, this is the second office memorandum. In this office memorandum, they have not stated about provisional. This, they have given the reference of the ROP notification 17th March 2017 in the office memorandum of 14/8/2018. And in the ROP 2017, my lord, is prescribed the procedure and the conditions.
Where is that?
That is quoted in page 49.
49. You're referring to the judgment. You have not enclosed that.
That is the book, my lord, that's why. the lordship will find in the last portion, subject to the conditions as follows. A, if there is any amount to be recovered as penalty, the recovery will be made as usual under existing rules of the government. If stoppage of increment is ordered as penalty, the date of effect of MSCPS benefit will be delayed by number of years equal to the number of stopped increments, and recovery for the excess drawn will be made as usual.
Now, where is the impugn notification?
Impugn notification, my lord, I have to impugn the impugn order, my lord, the lordship will find at page 54. 11%, page 55. And another office memorandum subsequently, my lord, they have issued in supersession of the earlier office memorandum dated 14/8/2018. In this office memorandum itself, they have incorporated the same conditions, my lord, at clause 2, page 68. Therefore, it is also put to challenge, my lord. This condition, incorporation of this condition, is not in conformity with the conditions prescribed by the ROP notification.
You
Therefore,
you have completed how many years?
I have completed, and since 1995, I am serving, my lord. I have more than 20 years.
No. In the criteria which is there in.
Yes, that I have fulfilled, my lord.
No, your claim is that you have not at all been considered, or you have been considered at.
Pursuant to the direction of this honorable court, they have considered my case and rejected. On the ground that the case is pending.
Prior to
that, no
it has
consideration.
never been considered.
Not considered.
Come back to the order of the court again earlier.
Yes, Lordship. Page 14, paragraph 6 onwards, it's the findings of the court, my lord. Page 48. I have considered the submissions of the learned counsel for the parties and have perused the materials placed on record by the parties through their pleadings. The state government has framed and notified the MSCPS for the regular state government employees by the notification dated 17/3/2017, which was published in the Assam Gazette in its issue dated 17/3/2017. As per the MSCPS, it provides only financial upgradation and shall not entail any change in designation, place, and nature of work, and change in the seniority of the person concerned in the gradation list. The financial upgradation involves grant of the increment in the pay band of the employee without changing its.
All right. Yes. So who's
We
supposed to
have filed
respond?
an affidavit in this case, my lord.
You have filed?
But my lord, we have filed already affidavit, my lord.
You have filed.
Also, kindly see the page 54, annexure B. This is the speaking order as per direction of the honorable court.
Yes.
Order dated 21 September 2022. This speaking order, they have already, they have challenged it, my lord. Lordship, may I read it, my lord, slowly?
No, we have read it.
Read it, my lord.
We want to know that in view of the directions of the court directions are very clear that you should be considered for provisional grant of provisional MSCP. But department considers it, saying that because of filing of charge sheet, what is that, prosecution sanction?
Yes.
Charge sheet has been filed and criminal case is pending.
No, is it charge sheet?
Charge sheet, madam.
That's it, my lord.
Where is that order? The impugned order again?
Impugned order, my lord, page 55.
55.
Pending prosecution, due to pending prosecution sanction against the officer.
Prosecution sanction, not charge sheet. Prosecution sanction.
Prosecution sanction has been granted
Then,
and such file in this case, my lord.
so has he been charge sheeted?
That's it.
Where have you stated that?
I think I have got from here, my lord.
That fact was brought in the earlier proceedings also, and the honorable court has duly recorded, my lord.
But in
In
terms
the
of the,
findings.
in terms of the ROP notification is entitled to provisional.
Yes.
That's the only thing he wants.
Yes.
My lord, at page 58, is the office memorandum, my lord. The office memorandum also clear.
That is also put to challenge here, my
My
lord.
lord, Lord, can see page 68. And clause 2, the financial arbitration is subject to the condition that there is no disciplinary criminal proceeding against the officer. Now, though one criminal case he is acquitted, the other case has been, my CBI case is pending and such it has been submitted. And of course, till July 2023, no Department of Proceeding is drawn. Today, I cannot say whether Department of Proceeding is drawn or not.
Not done, my lord.
So, the petitioner case is, my lord, rejected only because of that, my lord. They considered it, my lord. The submission made in the my lord, earlier petition, that has been considered. And
Where is that 14.8 notification?
Yes, 14, my lord, at page 42. The same condition is there in the new impugned notification. That is why this new notice of OM is also put to challenge here, my lord, with in the so
14
far
August
as clause
2018.
2.
Financial arbitration is subject to the condition that there is no discipline in criminal proceeding against the officer. Therefore, my lord, his case is not considered.
That finding has been, my lord, of this honorable court where it is already analyzed, my lord.
Same set of, if it is the same set of, my lord, allegations that the petitioner court has already, my lord, considered it. He can go for, my lord, contempt petition, my lord, my writ petition is not maintainable.
Once
Same-
the
same
order is
allegation,
passed, my lord, how
same
the contempt
thing.
will lie.
He said same thing and same allegations and same notification. Then instead of filing this writ petition, he could have preferred a contempt petition.
Order is
The order is not, my lord, complied with.
rightly or wrongly, they have passed an order, my lord.
Prosecution sanction was granted against the petitioner in 2017, 12 January 2017. He was not considered for promotion to senior grade 1 as per Rule 13, clause 3 of the Assam Civil Service Rule 1998. He was not promoted. Whereas the procedure of granting financial commissioner MSc stated every department shall have a screening committee in the month of November 2024. Committee will verify the length of service among students. All the cases where the government servants have completed 20 years, 10 years, 20 years, 30 years of the service and have no DP or criminal case.
This page number 49 is extract of the
Notification.
notification. Is whose notification? Assam government.
Assam government, my lord. That I have also annexed at page 56. Is the ROP notification. '57 is the
This notification, page lordship 59, last paragraph, C, clause 2, it has been mentioned, my lord. The committee in the month of January issuance consider all the cases of government servants who have completed 10 years of service, 20 years of service, 30 years of service. Previous 10 years.
So which notification are you reading?
This he mentioned is a page 50, 56. This notification continues to page 59. 59, last portion was to kindly see, clause 3. The committee will verify the length of service as on 1st January of the year in which the meeting is held and will verify if any departmental proceeding or criminal case is contemplated or under process against the government servants under consideration. SCS need not be considered for deciding the MSCP benefit. So apparently, my lord, case is pending.
Where is that extract by the court?
My lord, page 49, my lord.
No, 49, I know from which part of the
Oh, this
notification?
is my page, that extract is from, my lord, page 58. Page 58, Roman 7. The financial benefit of the scheme shall be given with effect only from 1/1/2017. However, the services rendered by the employee before 1/1/2017 and promotions SCPS benefit availed before 1/1/2017 shall be taken into account for deciding and determining the extent of the benefit under MSCPS. For example, an employee who has joined regular service in 1995 and his case has been considered in 2016. The service for the purpose of MSCPS shall be counted from 1995, and accordingly, he will be entitled for one promotion in 2006 and another in 2016. The first benefit under MSCPS will, in this case, start from 1/1/2017 and not earlier. If the post of an employee has been upgraded at any stage of the service, the same shall be considered as a promotion for the purpose of deciding the benefit of MSCPS. Similarly, if an employee decides to decline a promotion from for any reason whatsoever, his case will not be considered for the benefit under MSCPS. In case an employee is transferred from one department to another department in the same scale, the services in the previous department and promotions availed during that period shall be counted for deciding the benefit under MSCPS. If an employee is transferred from one department to another department to a post with higher pay scale, this will be treated as a promotion and the employee will lose his claim of MSCPS benefit. The past service rendered in public sector undertaking under any other state public sector undertaking at autonomous bodies, state level public enterprise, or any other statutory body shall not be counted for the purpose of MSCPS. If an employee is ordered by a government or any reason whatsoever to join at a lower post either in the same department or in any other department, he shall be entitled to the benefit of MSCPS provided that such order is not issued as a consequence of the departmental proceeding resulting into the reversion. Financial and other benefit which are linked to pay drawn shall be permitted on the basis of his pay fixed after the benefit of MSCPS. Pay drawn in the PB and GP allowed under the MSCPS shall be taken as the basis for determining the terminal benefits for retiring employees. Normally, the benefits under MSCPS shall be applicable from the first day of January of the year in which the screening committee has held the meeting and recommended the case. This would imply that any employee who has completed 10, 20, 30 years of service in the previous year.
Yes, we have seen it. Mr. Sutia, this circular, what is this notification?
Notification.
Clearly provides that in case of any criminal proceeding, he will be given provisional benefit.
Yes,
Page number 59. And this aspect appears not to have been considered in spite of an order by the court.
Speaking order passed by this.
No, speaking order is okay. We are not denying that there's no speaking order. But there is a specific order by a coordinate bench referring to this clause 5B14. And a direction is issued. Now, even that aspect was not even considered, whether he is entitled to provisional or not. There is no reference. So,
therefore, my lord, the notifications, office memorandum, whatever they have issued in the year 2018 as well as 2023, my lord, this should not contain this clause 2, my lord. This is not in
The
conform-
writ once issued will remain. We are not supposed to issue repeated writs. So better we draw up contempt proceedings. We'll convert this into a contempt. Because this order was passed inter party. You represented the department.
Yes. That is one of the the order directed to consider is one of
An order directed to consider has to be read in its entirety.
consider case of the petitioner for extending the financial benefit provisional in terms of the MSCPS and Office Memorandum 14/8/2018.
Hmm.
By taking into account that the petitioner has more than 20 years of service in SCS is without true regular promotion. After such consideration, a speaking order be passed. It is ordered accordingly. That is the order, Madam, direction.
Hmm.
So by virtue of this order, Madam, they have passed this speaking order.
No, in your, come back to the notification that you have, 14.8.
14.8, Madam.
Where is 14.8?
Page 42. Type copy 42.
Yes. A member of the civil service will be
No,
granted
before that, this is in
of the
pursuance
department office number
to
notification
the
number
notification dated 17 March.
2017.
Hmm.
And in the interest of public service, the scale is granted to the Assam Civil Service officers as given below. A member of the Assam Civil Service office will be granted the next higher grade pay along with the corresponding allowances on promotion of requisite qualifying period with the current grade pay as mentioned in the table above. Only if the officer has not been regularly promoted during the appropriate period. I think there is a corresponding allowance on promotion. His promotion was not given, madam.
Therefore, he's asked for MECP.
Promotion was stopped. And financial arbitration is subject to the condition that there is no disciplinary and criminal proceeding against the officer. That is the extent of the.
You are praying for setting aside.
Yes.
Of what?
My lord, this impugn order as well as this the impugn provisions of the office memorandum. My lord.
But office memorandum was not challenged earlier.
It is challenge in this case, my lord. Both the office memorandums are put to challenge.
Which both office memorandum?
This page 42 as well as 68, my lord.
42.
Yes, page 42 is the 14/8/2018 office memorandum so far as the clause financial upgradation. This in this portion
and
in the page number 68, my lord, is clause number 2. Because this cannot be incorporated. This is not in conformity with the parent notification.
What is the effect of 17.3 notification?
17.3, my lord, which prescribes the, my lord, conditions for grant of the MSCP. This 73 is the ROP notification, my lord, through which this scheme of MSCPS has been introduced. They cannot deviate from the, my lord, conditions given in the parent notification.
The general financial benefit is due to pending the prosecution against the officer, the disposal of which is P requisite for being considered for the grant of financial benefit. benefits under MSCP as well as prime school. This is a prerequisite condition, madam. Our affidavit, paragraph 7, my lord, we have stated detailed.
Yes. Paragraph?
Paragraph 7.
Seven.
Then 10 to the reply to the 10 of the the Quran states that revision of accused that the procedure for grant of financial upgradation as mandated. Case 92, turning to mandated under agencies of MFCPS stated as follows. Every department shall have a screening committee with a senior most secretary or any other secretary authorized by the senior most secretary itself. The head of the department under the control of the that secretary and financial advisor of the department shall be the members of the committee, and deputy secretary of the department shall be the member secretary of the committee. The committee in the month of January every year, we will consider all the cases of government servants who have completed 10 years, 20 years and 30 years of service in the previous calendar year. The list of such government servants will be prepared by the heads of the departments in the month of December of the previous year and submitted to the secretary for holding the meeting of the screening committee. The committee will verify the length of services as on 1st January of the year in which the meeting is held and will verify if the departmental proceeding or criminal case is contemplated or under process against the government servants under consideration. SCS need not be considered. All the cases where the government servants have completed 10, 20, 30 years of service and have no DP and criminal case against them shall be shortlisted for MSCP benefit.
Yes, Mr. Purkashta.
Yes.
Your challenge will have to be based on the premise that the 17 March 2017 notification has given you enforceable right and which cannot be curtailed by subsequent.
Yes. Because that
No,
notification.
but on what basis are you making this?
But that
submission, if at all?
notification is a statutory, my lord, enactment, my lord, under this ROP notifications, Assam Service Rule. ROP
Yes,
notice, my lord.
but how to be implemented? A committee is to be.
That is
set up.
also given. The procedure is also prescribed in the, my lord.
Maybe.
Yes.
But where is on what basis are you saying that there can be no deviation? It is depending, you belong to a particular department, this is by the personal department.
Yes.
So personal department feels that in case of pending DP and criminal proceedings, we would not like to give you the benefit.
But that will, my lord, that will frustrate the, my lord, the object of the MSCPS given in the ROP 2017, my lord. Because the conditions already given in notified, my lord, on what conditions even in the event of
some law.
Yes, lordship.
That
Even the
it
judgments are also
crystallizes
there.
into an enforceable right.
Judgments are also there, my lord.
Show us. What for are you keeping the judgments? If not to place it before the court. Yes, tell us.
I've given
This
some
is
marks, my lord.
Jharkhand.
Yes.
Jharkhand High Court.
I've given the paragraph 11, my lord.
Para 11.
The court has proceeded to examine the arguments advanced by the learned counsel for the petitioner as well as the learned counsel appearing for the respondent state.
This is on the case of whether charge sheet has been filed. In your case, it has been filed.
The date, my lord, when filed, before that I have completed the, that period.
Hmm.
Before filing of the charge sheet, I have completed the
Mr.
period.
Counsel, your argument before the court is that in view of the notification 17/3/2017 holding the notwithstanding criminal proceedings pending,
Yes.
you will be entitled to
Yes.
provisional.
Yes.
This is one. You are now trying to argue that before the charge sheet was filed, you had completed the required period and therefore you are entitled.
Both,
So
both
which
the,
one?
both the way, my lord.
How can it be both?
My lord, before filing of the,
If the second argument is to be accepted, you are abandoning the first. Why should we even look into the aspect of the notification being in conflict with 17/3?
in that you also have
Then we'll
entitled.
direct them to verify and pay whatever is there prior to filing of the charge sheet.
That aspect is
If you
also,
are happy with that.
that aspect is also earlier considered by this, my lord, court, my lord.
No, not like it.
And
That was.
date
not
of the
recorded.
filing charge sheet is recorded, my lord.
That was not mentioned, my lord.
The direction of the court is to consider your case in terms of the notification 2018.
Yes. As well as the MSCPS.
No. Penultimate direction is 2018. It is your case that this 2018 is in pursuance to 2017 notification. And 17 notification gives you the MSCP benefits.
Extend the financial benefit provision in terms of MSCPS and the office memorandum dated 14/8/2018.
Where is that judgment again?
Page 53, my lord. Extend the benefit provisionally in terms of MSCPS and the office memorandum dated. Both the provisions are considered, has to be considered.
See, the direction is to take into consideration
Yes.
the provisions of clause 5B14
Yes.
together with office memorandum 14.8.
Yes.
But office memorandum 14.8 is in conflict with.
Conflict with.
Then.
That's why, my lord, I put to challenge
So
here.
that's why you should have challenged it earlier. Why not constructive res judicata now?
Well, that is put to challenge, my lord, because they have rejected on the ground of that one. That's why I put to challenge.
No, they have rejected, but there was no direction by the court. There was no finding by the court that 2017 will prevail. Now, what is your argument?
But argument, well, 2017, 2018 office memorandum as well as 2023 office memorandum, my lord, where they have incorporated the impugned clause, my lord. That is not in conformity with the statutory provisions given in the notification date of 2017, my lord.
So you show us some law. This is with regard to cutoff date.
Cutoff date.
So if you are urging on the cutoff date, then we need not enter into the controversy.
Then again, they will, my lord,
We
reject.
don't know. You have to argue. You tell us. We are willing to hear you on this.
Then, my lord, I will place some authority, my lord, a date may given, my lord. On this, my lord, whether the office memorandum can supersede the, my lord, the mandates of the statutory notification. That cannot be. This is settled law.
So if it is settled law, you should bring the settled law. You know it. We don't know it. You have to enlighten the court. List again on after 2 weeks. The request of learned counsel. Mr. After 2.
A date may given, my lord.
What is the point? You are not coming prepared. You have to be prepared to argue a matter. What is the point in fixing date after date?
Otherwise, man, it's hard already, but some.
What hard? You have not even proceeded to hear because you have not placed the law. You place the law, we'll hear it.
Any date, man.
6th of March.
Obliged.
May I please your lordship? In this case, your lordship, the last occasion, lordship had asked me to get the PIF scheme, your lordship. Unfortunately, I could not get it. I need some short accommodation for that.
Lordship, here the petitioner served more than 17 years, 2 months and 26 days, lordship. under the scheme Prevention of Infiltrators of Foreigners, that is Border Police Lordship. But the petitioner served more than 10 years and below 20 years, which the petitioner eligible for proportionate pension lordship. This is the case lordship. And some common judgments are also annexed. Lordship will find at page 46 lordship.
Have you enclosed the PIF scheme?
No lordship.
You enclose it,
Could not obtain lordship.
then let him obtain. There is an order of the court.
Lordship, lordship.
In terms of the order of the court dated 7/11/2023, the government advocate was directed to produce a copy of the PIF scheme. Stop today, Mr. C. S. Zorika, Learned Junior Government Advocate submits that the same has not yet been made available to the council. He prays for further time. Mr. S. K. Sarkar, Learned Counsel for the petitioner, does not object to the prayer made. Placed again after 2 weeks.
Any fixed date, Lord?
6th of March.
Lordship. I live. Lordship.
May I please your lordship?
Yes.
So as per lordship, as per date, the last order dated 9/9/2023, respondent number 1 was directed to file an affidavit, and we have not received any copy of the affidavit.
9/9.
Yes. Yes, Lord.
There is no 9/9 order.
29/9, lordship.
29/9. Yes, State Council.
Pension.
Yes, my lord, whatever, my lord. Final pension PPP has been issued to the petitioner. And petitioner, my lord, what happened, I have received the instruction, my lord. The instruction says, my lord, that there is an objection that was returned to the, my lord, DC by the Accountant General, and that was meet up. And one overdue was 1 lakh something is there, 1,80,000, 28,683. That has been paid by the petitioner. Now I have received the instruction that final pension has already been issued to the petitioner. So lordship by dispose of the matter, he has got this.
You show it to him.
In fact, we have prepared the affidavit on the basis of that, my lord, that was not signed by the officers. Yes, sending letter.
Lordship, we have not received any pension amount, and
Amount that the order is there.
No, sanction is there, perhaps.
moreover, lordship, the amount that we have deposited of rupees 1,28,000, lordship, it should be reimbursed based on the.
Let us see the instructions.
Yes.
You are working as what? You are working as what?
Senior assistant.
Grade 3.
Grade 3.
That was, this anomaly was beat up. And that was corrected. And that has been again sent to the accountant general. Accountant general has thereafter, my lord, issued the final pension. 14/9/2021. Final proposal from the pension accountant general. Pension order is there, my lord. Pension payment order 9435112819 and 1. in favor of Upon Burman, retired civil assistant to the student. By letter of 23 February 2022. The letter is officially received to employ. There was provisional pension stop from July 2022 due to finalization of pension payment order. Upon paid to review his petition. After his prayer.
But this PPO has been issued. So why pension has not been released?
Definitely it will be released, my lord. That has been sent in 2022.
Lordship, he has not received any pension amount.
Whether he has got after instruction or not, I don't know. It is July 2022 that has been sent. And he paid only for one thing, to review his pay fixation. That was anomaly that has been made up, There cannot be. After issue of final pension proposal, that cannot be revised. There is a wrong in the scale that was corrected.
Then you bring it on record.
Yes, we have
Bring it
already
on
filed.
record. Let them bring it on record by
Yes,
way of an
yes,
affidavit.
Yes.
Lordship, you may also see annexure 10, Lordship.
Yes.
Lordship, paragraph 4.4,
Annexure?
annexure 10,
Yes.
page number 28. 28.
Yes.
Lordship, the amount which the petitioner has deposited of 1,28,000 so and so. So that needs to be reimbursed back to him.
That we'll consider after he files the affidavit.
Sure.
Your Mr.
P.P. Gogoi.
Mr. P.P. Gogoi appears for the petitioner. Mr. T.C. Sutia, learned government advocate, submits that the final pension payment order has been issued in favor of the petitioner, and therefore the claim, the prayer for grant of provisional pension, continuance of provisional pension cannot be accepted, as after finalization of the final pension, there is no provision for issuance of provisional pension. The counsel for the petitioner, however, submits that no pension order have been received. No PPO, pension payment order, has been received by the petitioner. In that, if that be so, let the government bring on record let the government file their affidavit to bring on record the PPO stated to have been issued by the petitioner. List again after 3 weeks.
But you may give a shorter date.
Let them file something.
Yes. Much okay.
Mr. S.K. Medi appears for Accountant General. List on 6th of March.
6th March.
My lord, the main grievance in this petition relates to non-payment of compassionate family pension measure. But meanwhile, the PPO has been issued. So I'm instructed to withdraw this petition with liberty.
My lord, I am the lordship that last occasion my learned friend is supposed to file rejoinder lordship. And I have no intimation about the PPO lordship because I am the second wife. I am entitled to get let my learned friend to file an affidavit lordship, additional affidavit to inform us or apply the copies for that to enable us to place our demands before this honorable court. If the PPO is issued lordship, whether that benefit is given to me lordship because I am the second wife lordship. And as per the new notification also lordship, past notification dated 17th August 22 lordship.
Yes, who's for the respondent department? Your account has been defreezed.
Yes, yes, it was kept on hold. Now it is operational.
So you're receiving the amounts.
Not yet. No money has been released, but PPO has been issued and the provident fund has also been processed, but nothing has been released yet.
Now, as far as second wife, what claim do you have?
Lordship, 50% of the
On what basis?
Lordship, there are some judgments of this coordinate bench of this honorable court, Lordship. I am relying on that.
After
also.
full bench?
Lordship after full. But,
No, after full bench, what remains?
and also full bench Lordship regarding the payment to be deposited in her account first wife, and that to be Lordship to disburse my share Lordship, so which is also, let me submit. And which is also discussed in that judgment Lordship regarding that. And apart from that Lordship, the notification dated 17 August 2022, in that notification amended Rule 143 to, if the family pension recipient does not divide the amount among the other beneficiaries in equal share, and on receipt of such complaint, the eligible family members, the competent authority shall issue orders appropriating the family pension among the other eligible family members.
This is on the basis of, this order is for what purpose?
For compassionate family pension. And also there is another judgment of the Honorable Court, Lordship.
You are placing this judgment
Lordship.
of Rupu Begum.
Lordship.
For what purpose?
That is, earlier Lordship, it was a compassionate family pension. And which she was receiving Lordship. Then I filed an objection Lordship. Then the authority has stopped the family pension. But then my learned friend came before this honorable court challenging the same Lordship. Then I filed my affidavit. And I am now relying on that judgment Lordship because since I am entitled to, as per this full bench as well as the, which I now referred before your Lordship of the coordinate bench of this honorable court, and as well as in 2006 also.
No. Come, why don't you come one by one? First, this judgment, for what purpose you are relying? What finding?
That is.
Rupu Begum.
I am.
You have a copy?
Lordship.
Yes. Which paragraph?
Paragraph 7, Lordship.
Paragraph 7.
Lordship.
Paragraph 7 is consent order. His second wife has agreed that we have no difficulty.
I was the second wife, Lordship.
Maybe.
And respondent was the.
Sorry, not the second wife.
First wife.
First wife. Respondent 7 was the first wife.
Lordship.
So first wife has agreed.
Lordship.
If he agrees, then we can close it.
Lordship,
we cannot compel him to agree.
No, Lordship. As per this judge, I am not on that Lordship because I have to survive Lordship having 2 children.
Whatever it may be, but this is not an authority that second wife will be entitled to 50%. Your submission is that second wife is entitled to 50%. That is your submission.
And that is another rule, Lordship, that there is the new notification of 17 August 2022. Clause 2.
Yes.
1 to 3, Lordship, I am applying that. Kindly consider that, Lordship.
Clause?
Amendment of 143, Lordship.
Clause?
Clause 2D, Lordship. First page, Lordship.
2?
2D, if the family pension recipient does not divide the amount among the other beneficiaries in equal share, and on receipt of such complaint from the eligible family members, the competent authority shall issue orders regarding.
Now you have to now refer to the definition of family members.
Lordship.
Who is a family member?
That is 143, Lordship. That is, I am also the family member, Lordship.
143. Let us have 143. Yes.
One thing I respect to submit, Lordship. I pray, Lordship, any other day, Lordship,
Any other day.
Lordship, next week.
All right. Any other
because I should have to bring some records which I have not, Lordship, with that. I shall try to satisfy your
At the request of Mr. K. Muzafar, Learned Counsel appearing for the respondent number 8.
Lordship.
Matter stands adjourned for 2 weeks. Mr. O. Loskor, Learned Counsel appears for the petitioner. Mr. Pegu for the state. Education. Education. Mr. Talukdar for Accountant General. Under 143, only wife.
Lordship.
Yes, the full
Let
bench
me-
decision there.
Let me, Lordship, I shall try to satisfy your Lordship. I am not on that Lordship because since she is the second wife, recognized by him also in his petition also.
Yes, I mean.
And apart from that Lordship, if the 50% Lordship, because I have also equal rights as per the division.
That is what we want to know.
And my lord,
So that Lordship, I will place that Lordship, any short date Lordship subject to accept.
my lord, since if PPO has been issued, if the respondent number 8 is aggrieved with the PPO, she can put to challenge it in
Lordship,
another
I have no
proceeding.
copy of
I
that
am-
Lordship, and since one matter is pending Lordship, she is not in a position to take Lordship. Her condition, she is not getting everything.
All right.
she has
When do you
taken.
want to tell us?
Lordship, any day subject to convenience of this honorable court.
Every day is convenient for me.
Lordship. that
8th,
is
8th of February,
8th of February. Lordship, please.
list on 8th of February. At this rate.
Instruction has been received, my lord, some time may be allowed for filing application.
Yes. Let us
Definitely,
A. Bora,
my lord.
Learned Council submits that instructions have been received. She would like to file an affidavit. She prays for some time. Mr. T. Sheikh, Learned Council appears for the petitioner. List the matter on 8th of, 6th of March. 6th of March, good for you? Interim order, if any, will continue till 6th of March.
Affidavits have not been filed by the respondent authority. We have not received the Barwise comment, but we need further few examination.
Not receive parawise comments.
Yes, Lord.
Then what is your grievance?
Lordship, the matter pertains to introduction of pensionary benefits for the employees of the Khadi and Khadi Employees Association, Your Lordship.
Introduction.
Yes, Your Lordship.
There is no pension.
Lordship, we are getting contributory pension provident fund, Your Lordship. They want to convert it to the general provident.
When can you file you have not received your instructions? You have not received instructions. How much time do you require?
2 weeks and
3 weeks.
we give a short date, Your Lordship. The matter was filed in June.
Get it by 6th. 6th of March. Learned Council appearing for the respondent submits that instructions sought for have not been received. It therefore prays for some time. Counsel for the petitioner submits that several opportunities have been granted earlier to obtain the instructions, but the same has not been fulfilled. Accordingly, let the matter be listed on 6th of March, by which date it is expected that the respondents will complete their instructions and file necessary affidavit. On 6th.
And kindly peruse the last order, 5/1/24.
Lordship, on 9/11/2016, the pension proposal was sent back, Your Lordship.
2000?
For clarification, 2016, Your Lordship.
16.
Your Lordship.
Then?
Seeking clarifications, Your Lordship, and in 2017, Your Lordship, it was resubmitted, Your Lordship,
Hmm.
to the pension department,
Then?
clarifying the position. Now, Your Lordship, after that, we do not have any communication, Your Lordship. The pension department.
Yes, pension. Who's for pension? Pension department. What instructions have come?
Clarification for reappointing authority. That was resubmitted by the school authorities. It was
Mr. A. Chakraborty, learned government advocate appearing for the pension department, prays for further time to obtain instructions. Ms. D. Mushahari, learned standing counsel,
secondary education.
secondary education submits that pension papers were submitted to the pension papers relating to the husband,
Husband of the petitioner.
late husband of the petitioner was submitted to the pension department
On 9/6/2017.
on 9/6/2017.
17.
And subsequent thereto, no communication has been received from the department. Accordingly, let the Department of Pension apprise the court as to what steps have been taken to pass appropriate orders in the pension proposal put up by the Department of Secondary
Yes, ma'am.
Secondary Education. Mr. Khandakar appears for the petitioner. Mr. Borpujari for Finance. You get your instructions on 16th February.
I'm on.
Obliged, my lord.
In this matter, the affidavit is ready. We have sent it for vetting, Lordship. 1 week time, Lordship.
Vetting by whom?
Lordship,
Who vets your affidavit?
Lordship, the officer, Lordship.
Officer.
One week time, Lordship.
Mr. C. Sharma, learned standing counsel, NC Hills, submits that the affidavit is under preparation and he prays for further 2 weeks' time to enable him to file the affidavit. Mr. Rayat Soikia appears for the petitioner. MSMM Kotoki for the animal husbandry.
My lord.
Mr. S.K. Medi for Accountant General. Anyone else? Mr. R. Borpuzari for Finance.
The last occasion, my lord, Animal Husbandry Department also, my lord, took time to file a affidavit matter.
Respondents, all other respondents are at liberty to complete their instructions and file necessary affidavit. List on 6th March. Both the matters are similar.
Similar.
Yes. Right. 6th of March. Item 48. Accountant General B. Chakraborty.
The State Information Commissioner, alert, he was seeking the benefit of the chief secretaries. Pay and allowances and other benefits of that equivalent to chief secretary. Under section 16(5), your lordship may kindly say that RTI Act.
RTI.
Okay.
RTI.
My lord, he was an Indian Audits and Account Service officer. He joined in the year 1983. Paragraph 2 I have stated, and in 2014 he superannuated as officer on special duty. Then thereafter he was appointed as State Information Commissioner at page 36.
Yes.
Page 36, your lordship.
36, yes.
The Governor of Assam is pleased to appoint Sri Busumutari as the State Information Commissioner in the Assam State Information Commission constituted by dated so and so under Section 15(3) of the Right to Information Act enacted by the Government of India with effect from his entering the office. He shall have to take an oath of affirmation subscribing before the governor or any other person authorized by him as per the form prescribed for the purpose of first schedule as per Section 16(3) of the Act before entering the office of the State Information Commissioner, Assam. His term, last sentence, his term of office, condition of service shall be regularized as per provisions of Section 16 of the RTI Act. Now, Section 16, my lord.
Yes.
May I take it? Well, the Section 16, two parts are there. If your lordship has taken the new copy, unamended,
22.
22.
Yes.
Well, 22, well, 16(5), your lordship can. 16(5), below, my lord, below.
Yes.
Before amendment in 2019. The salaries and allowances payable to and other terms and conditions of service of the State Chief Information Commissioner shall be the same as that of the Election Commissioner, and the State Information Commissioner shall be same as that of the Chief Secretary to the State of Assam. Now we are equivalent to Chief Secretary, and we are seeking the benefit of the Chief Secretary. Now, when it is amended, if your lordship goes above, this is amended in the year 2019.
Yes.
After the retirement of the petitioner, the salaries and allowances payable to and other terms and conditions of service of the State Chief Information Commissioner and the State Information Commissioner shall be as may be prescribed by the central government. Now this has become different now, 2019. Provided that the salaries, allowances, and other conditions of service of the State Chief Information Commissioner and the State Information Commissioner shall not be varied to their December days after their appointment. Now, provided further that the State Chief Information Commissioner and the State Information Commissioners appointed before the commencement of the Right to Information Act shall continue to be governed by the provisions of this Act and the rules made thereunder, as if the Right to Information Act has not come into 2019, had not come into force. So therefore, 2016, my lord, unamended.
So you are entitled to Chief Secretary's
benefit.
salary.
So we came before this court, my lord, seeking, my lord, your lordship will kindly see, page 45.
45. Yes.
I am directed to inform you that the representation forwarded by you regarding post-retirement benefit of facility of the service of one telephone and security assistant in respect of Busumutari, former State Information Commissioner, has been regretted. So these are the facilities available besides some pensionary benefit, my lord. And this post, page 55, your lordship,
55.
5.
Yes.
This is regarding this. The Governor of Assam, after due consideration, is pleased to decide that the officers retiring from the post of Chief Secretary and equivalent rank, who retired from Government of Assam and who are permanently settled within the state of Assam, may be provided with the facility of the services of one telephone and security assistant for discharging duties like attending telephone calls, etc., in the residence of the officers concerned. Now the payment part has been given, and subsequently it says, my lord, even if they settle outside the state of Assam, that your lordship will find at page 56. Now, your lordship will can you see page 58. 58.
58.
Yes.
Yes.
The chief commissioner, my lord. This is in respect of the state chief commissioner. I am directed to convey the sanction of the Governor of Assam to the grant of additional revised pension subject to the maximum of rupees 15 lakhs only as per annum as admissible as per rules to the retired government servant Himanshu Shekhar Das, former State Chief Information Commissioner, with effect from 1. This is the same benefit as was applicable to State Election Commissioner. So we came before this court, my lord, court's order at page 59. Earlier they said because he is not equivalent to, he is not the chief secretary, so therefore he is not entitled to get. Page 61 is the order passed by this honorable court. Two petitioners were there.
Yes.
May I, my lord, paragraph 3 onwards, Council for the Petitioner Right to Information Act has stood, or may I read, my lord, from paragraph 5 onwards?
Yes.
6, the state of the respondent, stand of the respondents in their affidavit is that petitioners would not be entitled as because they had not served as chief secretary. So that was the stand taken. Nor have they served in any equivalent rank as that of the chief secretary. Fundamentally, this state stand would be acceptable in as much as admittedly the petitioners have not served as chief secretary, nor had served as an officer in the rank equivalent to the chief secretary. But section 16(5) of the RTI Act 2005 creates a legal fiction in favor of the State Information Commissioner that by virtue of having been appointed and served as State Information Commissioner, they would be entitled to salaries and allowances payable and other terms and conditions of the service as that of the Chief Secretary of the State. In view of the legal fiction under section 16(5) of the RTI Act 2005, wherein it is statutory provided that the salaries and allowances payable and the other terms and conditions of service of the State Information Commissioner shall be as that of the Chief Secretary of the State the stand of the respondents that as the two writ petitioners have neither served as chief secretaries nor in the rank equivalent to the chief secretaries, they would be disentitled to the benefits of salaries and allowances and other benefits of that of the chief secretaries of the state would be unacceptable in law, in as much as by virtue of the legal fiction under section 16(5), they would be so entitled as statutorily provided. Accordingly, the respondents are directed to pass a reason order on the claim of the two writ petitioners for their service benefit, including retirement benefit and pension, if applicable in the same terms and conditions as that of the chief secretary to the state of Assam. So this is a clear direction. You treat him as chief secretary and pass reason order. So ultimately, they passed the reason order, very vague order, my lord. 65, page 65.
Yes.
My lord, it's a very big order by the commissioner.
They are referring to a judgment of this court.
Yeah, judgment that is totally not connected with the case in hand. That judgment, my lord, the State Information Commissioner, they were seeking pension equivalent to the State Chief Commissioner. My lord, may I just give the judgment, my lord? What is the copy? Judgment copy. Yeah, one copy, I think it is available.
Now, what is the stand of the state? I mean, we don't find any evidence.
We have received the paragraph comment only yesterday, Your Lordship. Some short time may be given to bring on record our stand, Your Lordship.
No, what are
Our
they?
stand is reflected in the order only.
Lordship, but basically, Your Lordship, from what I can make out, it is that their case, they have also relied on the Somasakaran Pillai one case was there, which I'm sure, I think is there already. That case is there in the Kerala High Court, Your Lordship, and we are relying on the Eken Niba case, Your Lordship. So let me file the affidavit, Your Lordship. Basically, what the delay for this receiving the Paravis comment is because this Paravis comment was initially sent to the office of the office of the Advocate General for his vetting, Your Lordship. It has been received back, and also I have received it yesterday only, Your Lordship. So let me find the affidavit, Your Lordship. Short accommodation.
This they could have said it earlier, my lord. They have been taking time every day when the matter comes up.
Lordship, this has come on, this is the third occasion. On the second occasion also, it was stated before Honorable Justice.
Now you tell us when you can file it.
Lordship, 1 week's time.
We'll have it on 29th
For disposal.
for disposal. Heard Mr. B.D. Das, Learned Senior Counsel, assisted by MS Hardek, Learned Counsel for the petitioner, Mr. C.S. Hazarika for the state
1 and 2.
respondents,
1 and
who submits that, respondents 1 and 2, who submits that
1 and 3. 1 and 3, Your Lord.
1 and 3. Who is for 2?
2 has been deleted, Your Lord, from the last occasion.
1 and 3 is the main point.
Okay, 1 and 3 submits that the instructions have been received and the affidavit on behalf of the respondents will be filed within 1 week. Taking the submissions of the learned counsel at the bar, let the matter be listed on 29th of February. An attempt will be made to dispose of the matter on the next date fixed. The affidavit, if any, to be filed by the state, may be filed before the next date fixed. Mr. R.K. Talukdar appears for the accountant general. Yes.
I think it.
Obliged.
This is no loss. Lordship, any matter will be fixed any other day.
Readings are complete. You filed your readings.
Yes, Spooner has filed their affidavit, Lordship. We may be allowed to file reply, Lordship.
Mr.
NH Lordship.
M.H. Law School Learned Counsel for the petitioner submits that 3 weeks' time be granted to file the rejoinder affidavit. M.S.
NN Sharma.
N.N.
NN.
Sharma appears for the respondents. Matter be listed after 3 weeks.
I know. Financial phase instruction note. Regarding payment of earlier salary.
Area salary.
Lordship.
Allowed, not allowed.
Finance Budget Department, my lord, has received a proposal for, my lord, an amount of 2.6 lakhs to be placed in the supplementary demand, my lord.
What is your claim?
My election had not been paid 1/3/2018 to 28/2021.
What is the amount?
As per Alexa's G Lordship that has been sent for proposal to the Finance Department Lordship. 23 page number. Serial number 16 Lordship.
16.
16 Lordship. As you section is 10, 1/3/2018 to 28/2022. Amount is 10,37,140 Lordship.
Heard learned counsels for the parties. Mr. R. Borpuzari, standing counsel for the finance department, has submitted on the basis of instructions received that an amount of rupees 260 lakh has been proposed to be placed as supplementary demand in the budget for the month of February 2024 for the purposes of meeting the requirement of payment of area salary in respect of, it is only in regard to this case.
My lord, they have stated it with regard to this case, but it is with regard to page
Has to be
20.
somebody else also.
Yes, my lord, page 23, which my lord has just now said.
Yes.
There are other persons also.
In respect of the claims of area salary of the petitioner and other similarly situated persons.
My
So,
lord.
accordingly, the learned Council for the Finance submits that matter be deferred and listed after 4 weeks.
Yes, my lord.
Mr. K.D. Sharma, learned counsel for the petitioner, does not object to the prayer made. 4 weeks?
No, sir.
List after 4 weeks.
Public.
Yes.
But please, your lordship, in the earlier occasion, this honorable court directed to produce DLC minors.
What is the name of the petitioner? You are a regular principal.
Regular principal.
You want a transfer.
Transfer, my lord.
But-
Accordingly, the transfer order was issued, my lord. And
But according to them, there is no provision for transfer.
and subsequently, my lord, due to non-influence, I approached before this honorable court, and this honorable court issue notice, my lord. And in the meantime, on that case, my lord, the respondent has said that the IS is not the appointing authority, my lord. And thereafter, my lord, the impugned order was passed, my lord. And accordingly, my lord, the petitioner also, in pursuance of the earlier case, my lord, stated that my lord, pendency, my lord, the directed the
But
director.
that is their stand is very clear that under the provisions of the new act, new rules, there is no provision for transfer.
But there is would be a provision for transfer, my lord. I am seeking transfer, my lord, due to my ailment, my lord.
Whatever it may be, but there must be a provision.
Initially, the online generated, my lord, transfer order issued, my lord, and subsequently, my lord.
Is it a case that once they're appointed to the same school for till retirement?
Yes, my lord. From here, from the act, the new act, it is, there is no provision for head of the institutions.
Is there a specific part?
There is no specific, but the definition mentioned in this act and the rules, my lord, this just does not include the head of the institutions. My lord.
Where is the act and the rules?
Act is in the education manual, rules is in the supplementary volume. It is not act.
What is the name of the act?
Act is, my lord,
Assam Elementary and Secondary
School Teachers
Teachers
Regulation of
Regulation of-
Posting and Transfer Act 2020.
2020?
My lord.
Is it available here? Regulation of posting. This is the rule.
Rules,
This is the rule.
rules is in the supplementary volume, my lord.
Where is Mr. Sutia? Where is Mr. T.C. Sutia?
Right. Okay.
Is the principal separately defined?
No, my lord, it's not defined separately,
Yeah.
but in the act, my lord, may I kindly come to the act.
Hmm.
In the act, definition of teachers is there, my lord.
Two chapter,
Hmm?
2P, my lord. Definition, my lord.
In the act, teachers means all teachers or tutors of both elementary and secondary schools drawing salary or fixed pay or honorarium from the government exchequer or from Samagra Shiksha Abhiyan,
Excluding.
Assam, excluding heads of school.
Heads means principal,
Yes, my lord.
head teachers.
Head teachers.
But, my lord, definition 2A, my lord. Kindly see, my lord. 2A. Cadre category or cadre means different category of teachers working in the state like principal. Here, my lord, include the principal, my lord, the teachers.
No. So this act is for governing the transfer of teachers.
Only
My lord.
teachers.
Which
my lord.
does not include
Principal, my lord.
principal. Even if we go by your definition of 2B,
My
you
lord.
want to say that there are different categories.
Categories, my lord.
So obviously then teacher category, the principal is not included in the teachers
lord,
category.
But also, my lord, the rule, my lord, definition 2 Roman 5, my lord. Teacher.
There also, my lord, head of the institution was not included, my lord.
My lord. Definition Roman 5, my lord. Teacher means teacher as defined in the act in section 2 clause P shall also include demonstrator, instructor, or any teaching staff engaged or appointed whatever name working government school to ensure.
But
Teaching
excluding
staff
heads,
means
excluding heads, head is not included. Head is not included.
But the humble submission, initially, transfer order was issued,
Because it
subsequently,
only they realize that you are not alive. They cannot issue it, so they withdrew it.
there is some provision, my lord, regarding transfer of the principal, my lord. The government employee, my lord.
Is there any circular to that?
No, my lord.
If you want to challenge the provision, then you have to go before the division bench.
But in
All right, you bring this on affidavit. Mr. N.J. Khatuni, Learned Standing Council, Secondary Education submits that as per the minutes of the district level committee, the transfer order of the petitioner was cancelled in view of the provisions of section 2B,
2P, my lord.
2P of the Assam
Elementary and secondary school teachers.
Elementary and Secondary School Teachers within bracket Regulation of Posting and Transfer Act 2020. Read with the rules. What are the rules?
Yes, sir.
Where are the rules? Read with the Assam Elementary and Secondary School Teachers Regulation of Posting and Transfer Rules 2022.
22.
Stop. It is submitted that in terms of the provisions of the Act and the rules, in the definition of teachers, the principal or the head of the institution is not included. Therefore, the claim of the petitioner or prayer of the petitioner for transfer has been recalled. Mr. Patgiri, Learned Counsel for the petitioner, submits that his position is not correct in law. Accordingly, let the respondents bring the same minutes by way of record, on record by way of an affidavit. Let the matter be listed after 3 weeks.
Obliged, Lordship.
Offline.
Yes.
The petitioner he retired from service on 31/12/2017. And since then, he was not paid his pension either provisional or regular. And my lord, by an order dated 9/11/21, the deputy commissioner takes it upon himself to sanction a disciplinary proceeding against the retired person, which is against the pension rules.
1 minute. Yes, yes, please.
My lord, if lordship would kindly have a look at the rule 22 of the pension rules, specifically says that even in the case a departmental proceeding is initiated or held to be as per law, during the pendency is entitled to a provisional pension. That provisional pension has also not come. They want to file an affidavit, there is no difficulty regarding the disciplinary proceeding, whether it is valid or not. But my lord, two occasions they have taken time only to come up with a stand whether why the provisional pension is not being paid to me. That's why.
Yes.
Lordship, as per instruction received, Lordship, as per instruction, it is stated that some discrepancies were reported, Lordship, and departmental proceedings pending. That's why the Lordship, provisional pension is not released, Lordship.
My lord, in the interim, lordship would refer to rule 22 and grant me the provisional pension till culmination of the proceeding.
Lordship, we'll file affidavit, Lordship, 2 weeks.
That is what the law says. Provisional pension, if a person has to wait for 5-6 years.
Learned counsel for the parties. Mr. A. Talukdar, learned counsel for the petitioner. A. Chakraborty, learned counsel for the petitioner. For the government submits that what you want to file your affidavit.
Lordship.
That instructions have been received.
Lordship.
Instructions have been received. You'd like to file the affidavit within a short period. Stop Mr. Muzumdar, learned counsel for the petitioner, however, submits that during the pendency of the proceedings, the petitioner is entitled to provisional pension in terms of Rule 22 of the Assam Pension, 1969. So, in view of the submissions made by the counsels for the parties, let the matter be listed again on after 3 weeks, by which time it is expected that the respondents will file their affidavit as prayed for. Meanwhile, the respondents will also consider the case of the petitioner for release of provisional pension under Rule 22 of the Assam Services Pension Rules 1969. If the provisional pension as provided under Rule 22 has not been released by the next date, the respondents will apprise the court the reasons therefore. List after 3 weeks.
Let's see, for the respondent number 4.
Who is respondent
On behalf
for?
of other.
Huh?
On behalf of other, respondent number 4.
PWD.
AG.
Accountant General. Accountant General, Mr. Swenso. Yes.
Lordship would fix a date, perhaps.
4th of March.
Publish.
4th of March.
Publish.
My lord, in this case, I have filed the affidavit today, my lord. Most probably that is not in record.
We have an extra copy. We can furnish that because we are anticipating a this submission from my friend. My lord, your lordship will find basically the gist of the affidavit which they have filed in the morning is that they are not in a position to comply with the order of the court because there is a order of the division bench operating, which is, my lord, has no relation so far the facts of this present case is concerned when there is a specific.
Let the affidavit come on record. Let the affidavit come on record. We'll call it. If they filed it, we'll get it by next week. And what was the direction of the court?
My lord, direction of the court is at page 24, paragraph number 23. And this gentleman has, in the meantime, petitioner has been superannuated from service.
Yes, what is the direction?
Paragraph number 23, my lord. Needless to say that the consequential relief that Mohammad Nusad Ali would be entitled by virtue of being provincialized from 1/1/2013 be given on current basis from the month of November 2021 and the area within a period of 6 months thereof. This was passed in, my lord, 2000. This order was passed in the on 28/9/2021. And already almost more than 2.5 years has elapsed, madam. And I'm surprised, madam, your lordship will kindly see the copy of the affidavit which they have filed at paragraph number 9.
No, we'll look into the affidavit, let it come on record.
They have virtually trying to overreach the order of
We'll
this.
look into it.
Or your lordship may direct the personal appearance of this gentleman, madam, who has filed this.
One appeal is also pending, my lord. That has been.
We'll see about that. First, get the affidavit. Why have you filed it today when the matter is there? You should have mentioned before the court.
No,
You could have got it.
my lord, yesterday I served the copy, my lord.
Has it been filed or not?
Yes, file, my lord, file.
File.
Document number is also there.
Okay. Mr.
S. Das, my lord.
S. Das, learned counsel appearing for the
I am for, my lord, pending counsel higher education, my lord. I am appearing for
respondent 2 and 3.
one, my lord, commissioner.
For all the, you are filing the affidavit on whose we have respondent 1. Has submitted that the affidavit on behalf of the respondent 1 has been filed today. Mr. B.D. Kaur, learned senior counsel, assisted by MS, submits that a copy thereof has been served on the petitioner. However, the affidavit stated to have been filed is not available in record. Therefore, registry to press out the affidavit stated to have been filed with respondent 1 and connected to the case record. List on. Twelfth. 12th. All right. Let it be on 12th February.
But can it be after 13th, my lord? Because 12. Much of it.
As per the Lavazima Court Order date 12/9/2022, the service is completed upon respondent number 5 to 7, and it has been already been appeared to file their wakalatnama.
Yes. Any.
So,
as per Office Note 12/9/2022, which reflects the order of the Lavazima Court, as per the order of the Lavazima Court 12/9/2022, since notices have been served on the correct address in respect of respondent 5 to 7 and AD cards or answer notices also have not been received, it is deemed to be served in view of Section 27 of Penal Clauses Act, read with Order 5, Rule 9, Sub-Rule 5 of CPC. Stop. As such, the notices on behalf of respondent 5 to 7 have been are held to be served. You are where are you working now? You're retired.
I'm retired.
You're retired.
So,
Yes, Mr. D. Upamanyu for
1, 2, and 4, Lordship.
1, 2, and 4 appears for 1.
I'm for 9, my
Mr. R.K. Talukdar for respondent 9.
9.
Mr. Choliha for 3 and 10.
11 to me,
Yeah, got PKT for respondent 5. Although it is held to be served, but none appears. Accordingly, let the matter be listed for admission on 4th of March.
In the meantime,
In the meantime, the parties may exchange the pleading.
Highly obliged.
this after 5. এটা বস্তুখানি এটা আমি আই এখন ফাইল কৰিছিলো না এখন যদি if it may please your lordship.
Yes.
Your lordship, as of today, I have received a copy of the affidavit that they have filed. I'm not sure whether they have filed. They have filed it as of today. Your lordship, I have
Filed today.
Yes, madam.
It is submitted by the learned
Your lordship.
counsel for the respondent, Mr. S.P. Das, that the affidavit on behalf of the respondents have been filed today. However, the same is not available in the case records.
Your lordship, there's one more.
Registry to trace out and connect the same to the case records.
Your
Yes.
lordship, in the IA, in the affidavit that they have submitted, they have furnished an order, your lordship. The IA will be rendered infructuous if that order is there. I have not obtained instructions from my client. As of yesterday, that order has not been received by my client. The release of provisional pension.
We don't have the affidavit. That's what we were directing. So let the matter be listed after 2 weeks.
Indeed, yeah.
Be after 2 weeks. Mr. Talukdar,
For respondent 4, my lord.
for respondent 4. Anyone else? Mr. Chakraborty for respondent 1, Mr. Choliha for
Respondent number 7.
7. Let it be after 2 weeks.
Your Honor, a date may be fixed if it is possible, Your Honor.
6th of March. 6th of March.
I think the lordship. As per laws in code order dated 30th of January, my lord, service upon respondent number 5 and 6 is completed.
As per Lozima Court Order dated 3001/2024, service on respondent 5 and 6 have been held to be complete. Who are 5 and 6? There is no 6.
I have 5 on IA, my lord, for
Huh?
implement. Yes, 5 and 6 is there.
Oh,
6 is principal.
5 and 6. You are a teacher in that school.
Yes, my lord.
You take dusty service on 5 and 6. The petitioner will also take dusty service on 5 and 6 and file an affidavit of compliance to their effect. List after 3 weeks for orders. Because you're a teacher in that same school.
Yes.
So you take dusty service.
Yes. Obligement.
May I please? Lordship, before submitting my learned pen, I would like to submit lordship instruction on was sought for lordship in this matter, but yet to be received lordship. That's why I may be allowed to 2 weeks time more to lordship.
You are representing?
All the respondent, I am for the housing board, sir.
Housing.
Housing board, lordship. For all the respondent, 1, 2, and 3 lordship.
Yes.
I have no objection. You have to file this affidavit.
Your name, please?
I am T.R. Gogoi. lordship.
T.R. Gogoi, learned
Lord.
standing council,
Assam State Housing Board.
Assam State Housing Board. Praise for
2 weeks time lordship.
2 weeks, 3 weeks further time to obtain
Lots.
his instructions, complete his instructions and file necessary affidavit. If so advised, Mr. S. Bora, learned counsel for the petitioner, does not object. List after 3 weeks.
Master.
The fact Magmal, it is seen, none of the lawyers appeared. Thereafter, I inquired to my junior, they said that though it was listed in part 2 hearing, but they were told that it will come in part 1 list, so need not be worried. And that's why the reason.
These statements are not there in your pleadings.
No, after your lordship's calling all the records.
No.
Now from the order sheet appears on that.
What is the writ petition about?
as regarding unpaid salary.
You are representing all the writ petitioners.
No, 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 only in this case only here's Hafizur Rahman. So my case may be taken up for hearing on merit.
Before that, you'll have to be restored. We have not even passed an order for restoration.
In that case, it was done, but thereafter some development has there.
Which case it was done?
Uh,
We did not do it.
In this case, on 19/1/24, but that was on the basis of the part 1 and supplementary.
That's right, it was not restored.
Yes.
This is the matter. This is the matter where we directed the registry to place on record.
No, no, on 19/1/24, your lordship allowed restoration.
No, no.
But that was on the basis of part 1.
We did not allow it. You see the 19-1 order. We thought we'll allow it. But upon examining the matter, we found that it is listed in part 2 and your pleadings are not there.
Yes, yes, that.
Therefore, it was listed. Why do you say that it was condoned?
Lordship may consider that.
Why should we consider? Why should we consider such a
No, our
on such irresponsible statements?
No, our submission is this, so many lawyers are there.
So
None
many
of-
lawyers are not here. You are there. You are now praying for restoration of your petition. Why are you putting the blame on others?
No, no, I am not blaming. I am only saying there is some misunderstanding.
There is no
perhaps.
misunderstanding.
Because none
You
of the
simply
lawyers
did not.
appeared.
You simply did not place it on record that it was listed in part 2.
Part 2 here, yes, that was not brought.
Then
Then in that
why
case,
should
then-
we? Why should we overlook that? Why should we not consider this to be a suppression of fact? That you filed an application by an affidavit saying that it was not listed in part 1 or daily
Yes.
list or supplementary list, but no statement with regard to
Part
hearing
two.
list.
Actually, at that time, we are unknown about that. Now, lordship has called the record. Now, from the order we see, none of the lawyers appeared. So, in that view, we will challenge this, we'll, on the basis of part 2 hearing list, we will.
So
file this.
on what ground are you praying for arrear salary? Is there any affidavit filed?
They have not filed it.
Then
It is their duty, my lord, but their order is there in my favor. They appointed me.
what arrear salary for what? For which period?
Yes, that my lordship may kindly see. WBC 6786, prayer portion may be seen. my lord. But some amount, page 15 of the writ petition. I am told that from this year,
You want arrear salary and current salary
current salary. Some amount of
with effect from
salary,
94.
no, in 94, that was first prayer.
Hmm.
Secondly, or that is there, when we are regularly appointed on 31/2006, kindly see page 15, last part. Of the period without delay with effect from 1994 or even after 31/2006, when the director appointed him, right, Annexure 8.
Now, why for a salary of 2006, you filed a writ petition in 2017? Why?
No, earlier there was various writ petition was filed. Those writ petitions order, your lordship may kindly see page 71, and then page 79. So all those writ petitions were unattended by the authorities.
In the manner in which, in such callous manner that you have filed the petition, we are not inclined to restore it.
We have already stated that due to this oversight.
How
But
can it be oversight,
First-
the council? Where have you stated it is oversight?
there are several petitions. That is why, my lord, some complexity is there. Earlier, we filed that petition. Thereafter, it was seen in the
Show
part
us the
1.
paragraph, show us the paragraph where you have stated it. You have not even stated it here.
It was stated, it was
Hmm?
stated,
Where, where?
I'm showing my note, that is. Page 6 may be seen, but page 6, IA 325. Here, para 4. The petitioner makes sure that if the delay, the council for 3 occasions also has dismissed the writ petition by order dated 11/11/21. Then lordship another dismissed for default, not on merit. That is, here so many, I actually in this case, my lord, we are also confused because of this, that it may be seen, my lord, MC 11. Can you say MC 11? Para 4, page 6.
Hmm.
The petitioner makes sure that the non-appearance of the learned counsel for the petitioner was a bona fide mistake and due to oversight of his lawyers, to which they beg unconditional apology. That we have made.
No, no, this is filed by the affidavit is sworn by the person concerned. He was not before the
No,
court.
no,
He is
it is-
represented by lawyers.
Yes, oversight is by lawyer.
Then,
No, it is, affidavit is by lawyer. Shafiqul Islam. He is the lawyer, one of the lawyers.
no, but this is, we want a specific statement. Exactly what happened. You're skirting this information. If you want a consideration for restoration, please bring it on record. What happened?
That 2 weeks time may kindly be taken.
We have given you enough
All
time.
events we will discuss.
We have given you enough time.
No, today my lord lordship called the record, that's why my lord. we
The
did not
records
file.
are here. This,
We
Mr.
want
Counsel,
to
is a counsel of your
say?
standing. Kindly listen, Mr. Mahmood, counsel of your standing. We accepted whatever you said. But for a lingering doubt, we made inquiries and we found that the statement you made in court is not correct.
Not correct, so far this part 2 is concerned. Otherwise, part 1 is supplement, that is correct.
No. This matter was never in part 1 and part 2, the supplementary. It was always in regular hearing list. So there is no occasion of matter being listed.
Actually, we wanted to file a comprehensive affidavit, but today lordship only called for the order, particular order. So we did not file. So now all the IS may kindly be allowed to be not pressed, and we will file a comprehensive affidavit stating all the things.
Whatever you want to place, you place it here. We are giving you 2 weeks' time. Mr. Mahmood, learned counsel for the petitioner, prays for and is granted 2 weeks' time to bring on record additional affidavit in support of his contentions made in the IA number, Miss Case 11 of 2022.
Public 2023.
23. Let the matter be listed after 2 weeks.
One thing, my lord, actually, we have also charged this Guwahati High Court website. This order is not found. So we may be allowed to take a Xerox copy from this.
You approach the registry. If the registry doesn't allow, you come and inform the court on Monday.
Yeah, please. My lord, matter relating to my lord payment of family pension. My lord, is a long pending case, my lord, because of my lord earlier civil suit was pending in the court below, my lord. For the civil judge senior division, Pujai Sankadev Nagar, my lord. It is why, my lord, it was not disposed of. Now, my lord, it is clear, my lord. I have submitted, my lord, the copy of the appellate court, my lord. On 18/1. What happened, my lord, is respondent number 8. He claimed to be the husband of the deceased, my lord, one Binubala Bora. And my lord, he was falsely claiming, my lord, and initially he was got a degree, my lord, from the municipal court. And appeal, my lord, it is reversed. The appellate judgment is before your lordship. We file it on 18/1.
Family pension, my lord, and petitioner. is-
You are whom?
You are my lord, is the husband. My lord, respondent number 8, he is saying that I am husband, okay, but she converted to Islam and I got a second
Who
marriage.
is for respondent 8?
My lord, we served the copy. We served the copy, my lord. He, many times, my lord, he not appearing, my lord, many occasions.
Now, what orders have been passed by the department?
Department, my lord, for pendency of this, my lord, civil suit, my lord, nothing has been, my lord, released.
Where is the order of the civil court?
Yes, my lord, I filed affidavit, my lord, on 18 January 24. It is in the record, my lord. We have checked it.
Yes. Yes. What is the finding there?
Finding, my lord, this claim of the respondent number 8, that he is the husband, it is rejected.
Where?
Yes, my lord.
Which part?
Because, my lord, this earlier, my lord, this declaration to be the husband of respondent number 5, it is reversed. So, my lord, now, my lord, it is clear, my lord, it can be disposed of, my lord. Because the matter relating to family pension, I is 73-year-old person, my lord. Lower appellate court, my lord, rightly hold that even there is marriage, it would be void marriage. Because earlier marriage never, my lord, dissolved. Respondent authority is very much aware, my lord, because, my lord, earlier one repetition, and in that repetition, Honorable High Court directed, my lord, to examine and release.
What is the private respondent?
Private
8.
8.
8.
Man.
Says he's filed a wakalat nama. Wakalat nama kothay? Hello. Private respondent number 8.
One advocate, namely Sira Datta, my lord, is appearing for respondent number 8.
Yes. Any submissions from the respondents?
So for respondent number 6 and 7, my lord, I pray, my lord, their name may be struck off, because, my lord, a small amount lying, my lord, with the LIC and, my lord, SBI life insurance, my lord, I pray separately, my lord, so their name may be struck off.
So
6 and 7.
I'm appearing for respondent of 5 and 6. No, so for respondent of 5 and 6 concerned lordship, the State Bank of India has nothing to do. And then no relief has been claimed against respondent of 5 and 6.
So, my lord, 5,
Come
6
to
and
video. Respondent number 8, item number 12.
5, 6 and 7, my lord, name may be struck. I shall praise, my lord, for.
No. Why did you edit them as parties? For what purpose?
Because, my lord, some amount is there in the name of wife.
No, so for State Bank is concerned, no relief has been claimed. Rather, they are claiming against SBI Life Insurance Company. So SBI Life Insurance Company is totally a separate entity than State Bank of India.
But you have a prayer here for LIC policy and SBI life insurance policy.
The SBI Life Insurance Company is not a party out here.
Very well, but LIC,
LIC is party.
you are representing LIC.
No, Lord, sir, I am for the elementary department, Lord.
Mr. Nondi,
I am for Esperanza 5 and 6, State Bank.
not even LIC.
No.
LIC is not a party.
LIC is
LIC
party, but I
party.
do not know who is representing.
LIC is part. My lord, I shall, my lord, press separately, my lord, department. That is why, my lord, name of 5, 6 and 7 may be start.
Lord, sir, I am for the elementary education department, Lord, sir. My only prayer is, Lord, sir, perhaps that status, if it is not released.
Not
will
really,
be-
not
released.
not really. Because
Okay,
of
heard,
that-
learned counsel for the parties, this writ petition is filed by the petitioner. Who are the what legal heirs? Who are the legal heirs?
My lord, is husband and son and one daughter. Son,
Legal heirs?
Yes.
They are legal heirs?
Yes, yes.
Have you enclosed a legal heir certificate?
Yes, my lord, I have.
Who claim to be legal heirs of late Binubala Bora. Stop. Late Binubala Bora was appointed as LP school teacher by the order dated 6/10/1990 and was posted as Nagya Palm LP School, Jamunamukh. Stop. Subsequently, she was posted at Kandulimari LP School, where she joined on 9/10/1990. Stop. The services of late Pinubala Bora was confirmed by orders of the Deputy Inspector of Schools, Hojai, by the order dated 19/9/2005. Stop. Had she continued in her service, she would have superannuated on 31/1/2018. Stop. However, during her tenure, she expired on 5/9/2013, leaving behind the writ petitioners as legal heirs. Stop. While the petitioner during her service period was posted at Kandulimari LP School, to where was her last posting?
My lord, it was, my lord, Sadargaon Muktab, my lord.
Subsequently, while she was serving at Kandulimari LP School, she was again transferred to Sodorgaon Muktab at Nilbagan. Stop. While she was transferred to Sodorgaon Muktab at Nilbagan, it became difficult for her to commute between her residence and the school, which is about 25 kilometers away. Stop. As such, she purchased a plot of land in Nilbagan and constructed dwelling rooms and started to reside thereon with her youngest son, namely writ petitioner number 3. Stop. Initially, the writ petitioner number 3 started dwelling in the said house along with his late mother. Subsequently, he returned back to Jamunamukh to prosecute his study, leaving his mother alone. Stop. The petitioner number one, namely the husband of late Binubala Bora, owns cultivable land and dwelling houses at Kotiatoli Gaon in Jamunamukh, and he has been living in the village Kotiatoli Gaon along with his sons and daughters and undertaking cultivation. Stop. It is submitted that pursuant to the demise of Binubala Bora, petitioner number one lodged his claim of family pension and retirement benefits. Stop. A legal heir certificate was also submitted along with next of kin certificate from the Sarkari Gaon Bura of Jamuna.
My lord, may I submit one thing, my lord? In page number 19 is the legal heir certificate. Name of the petitioner number is not there. Page number 19 annexa E.
Huh?
Page number 19 annexa E, my lord. That is the legal heir certificate. Name of the petitioner number one, that is the husband name is not there in the legal heir certificate. And voter list, my lord, that is 1993, my lord. Which is included.
Whatever.
In service record, my lord, my name is there, then I scrutinize it, my lord. In service.
As a
my
nominee. As a nominee.
Not nominee, as husband.
The petitioners thereafter represented before the department for claiming the pensionary benefits. Since the pensionary benefits were not granted, the petitioner number one approached his court by filing WPC 1595 of 2015, which was disposed of, directing the state respondents for passing a speaking order, directing the Deputy Inspector of Schools for passing a speaking order within a period of 2 months. Stop. The Deputy Inspector of Schools thereafter, by order dated 3005-2015, held that he was unable to settle the claim of family pension as the block elementary education officer, Jogi Jan, did not send the requisite records. Stop. The petitioner number one thereafter filed contempt petition number 551 of 2015 against the DI of the schools. Stop. Pursuant to issuance of notice, the DI of the schools preferred a review petition, being review petition number 67 of 2016, for review of the order dated 23/3/2015, disposing of WPC number 1595 of 2015. Stop. The grounds urged in the review petition is that one Muhammad Rabil Hussain, within bracket respondent number 8, herein, claiming to be the husband of late Binubala Bora, and therefore the pension papers, pension order, pension payable to the petitioner number one could not be settled. Stop. This court, by order dated 8/8/2017, passed in review petition number 67 of 2016, reviewed the earlier order, recalling the same, and WPC 1595 was 2016 was restored to file. Stop. Further direction was issued to implead the said Rabiul Hussain as a respondent. Stop. During the pendency of WPC 1595, 2015, after the same was restored, the respondent number 8, MD Rabiul Hussain, filed a title suit being TS 71 of 2015 on 2/3/2015. Stop. The said respondent number 8 did not agitate, did not urge, did not contest the the writ petition being WPC 1595 of 2015, and instead preferred the title suit number 71 of 2015. Stop. Upon being informed about the title suit filed by the said respondent number 8, the you did not contest the title suit.
My lord, he contested.
You
My lord, I contested.
contested.
My lord, initially, no. Initially, it was ex parte order
Uh,
and appeal preferred by my lord petition.
Although initially judgment and decree was issued ex parte, the petitioner number 1. Subsequently, on appeal, the matter order was interfered with and the matter was heard again. Matter was redecided. And by what is the judgment and decree date?
Date, my lord, 10/1/24.
Huh?
10/1/2024. My lord, in
And
the
subsequently by, no, 10/1 is the judgment and of,
appellate court.
no, did you, the order in the title suit was ex parte.
Ex parte, yes.
You did not contest.
Yes, I could not, my lord.
You preferred the appeal,
Prefer.
which has been granted now.
Now,
Okay, say that.
advertisement.
All of it. Preferred the title suit number so and so, which, however, was not contested by the respondent by the petitioner number 1. Stop. The Court of Munsif, by judgment and decree dated 6/4/2017, declared, passed an ex parte decree that that late Binubala Bora, that the plaintiff slash respondent 8 herein, MD Rabil Hussain, was the lawful husband of late Binubala Bora. Stop. Upon the order or upon the judgment and decree, upon the judgment pronounced by the learned Munsif came to be served on the petitioner, an appeal was preferred, being titled Appeal number 07 of 2021. Stop. The Court of Civil Judge Senior Division Hojai, by judgment dated 10th of January 2024, interfered with the order under appeal passed by the learned Munsif, and declined to answer the questions raised in the appeal, namely, declined to answer the questions named in the appeal in negative, in affirmative. Stop. The questions before the appellate forum are as under para 13, page 63. Stop. Para. The said judgment of the appellate authority is brought on record by way of the additional affidavit filed by the petitioner on 18th of January 2024. Para. Perusal of the case record reveals that notices have been served on all the respondents, including the private respondent number 8 and is shown to be represented by a learned counsel whose name by executing proper wakalatnama. Stop. Mr. Nandi, KK Nandi, representing respondent 5 and 6,
5 and 6.
submits that there is no claim against the respondents 5 and 6. The claim of the petitioner in the writ petition is in with respect to the SBI policy number so and so, page number 12, and
SBI
for
life
releasing of that
insurance.
amount, along with the LIC policies number so and so, so and so. Stop. In respect of either of these claims, the SBI is not at all connected. Therefore, respondent number 5 and 6 are not are not necessary parties at all. Where Mr. Chauhan, learned counsel to the petitioner, submits that their names may be struck off and liberty may be granted to proceed against the appropriate authority for release of the claim in respect of SBI policy number so and so and LIC policy number so and so separately. Where Mr. P. Soikia, learned counsel representing Director of Pension, has raised an objection with regard to the legal heirs certificate, saying that the said certificate does not contain the name of legal heir certificate dated 13/11/2014, does not contain the name of the petitioner number 1. Stop. Mr. P. N. Sharma, learned standing counsel, elementary education.
1, 3, and 4.
What is your submission? Submits that the petitioner can approach the authorities, who in turn will examine the claim of the petitioner and necessary orders can be passed thereon. Stop. Where having heard the counsels for the parties, and upon a careful perusal of the pleadings on record, including the order of the appellate court, including the order dated 24/1/2024 passed by Civil Judge Senior Division, Ojai, in title appeal number so and so, it is seen that the competent court of civil jurisdiction has authoritatively rejected the claim of the private respondent number 8 that he is the lawful husband of late Pinubala Bora. So, although the respondent, as discussed above, although the respondent number 8 is represented by the counsel, by a counsel who has executed, who represents the respondent number 8 by executing, by filing a duly executed power. At the time of hearing, none has represented the respondent number 8. Stop. No affidavit whatsoever has been filed by the respondent number 8 pursuant to the, in response to the affidavit, in additional affidavit filed by the petitioner, bringing on record the order of the appellate authority. Stop. No counter affidavit otherwise also has been filed by the respondent number 8, as well as the other respondents, although notices in the matter was issued as far back as 10/7/2017. Stop. It is submitted at the bar that at present the pensionary benefits payable in respect of late Pinubala Bora has not been decided or released by the competent authority in view of the interstate dispute as regards the claim of, as regards the dispute regarding the interstate claims of the petitioner versus the private respondent number 8. Stop. Under such circumstances, in view of the order dated so and so passed by the Court of Civil Judge Senior Division in title appeal number so and so, there is a finding. The finding by the civil court that the respondent number 8's claim of being the husband of late Binubala Bora has been overturned and negated. Stop. Under such circumstances, the respondent authority, more particularly the respondent number 1 will decide.
Director of Education Limited.
Director,
You will approach response number 3, Lord. Director of Elementary Education.
Deputy Inspector. Who will decide? Deputy Inspector.
BIF fiscal, he will approach. The petitioner will approach.
The
BIF
Deputy Inspector of Schools will examine the matter and pass appropriate orders on the basis of the finding of the competent court of civil jurisdiction and release such pensionary and other retirement benefits in favor of the legal heirs of late Benubala Bora. What is the name? Benubala. Binubala. Bora.
Vinupala.
Stop. In view of the finding by the appellate court of Civil Judge Senior Division, Hojai, in view of the findings, in view of the judgment and order, judgment dated 24/1.
Melody 10-1.
10/1.
10-1-24.
10/1/24. The deputy inspector of the respondent, what department is this? Elementary. Elementary education, director elementary education or secretary elementary education department. The elementary education department will process the claims of the petitioner in respect of grant of family pension, upon making due verification in the matter. Writ petition accordingly stands disposed of. The exercise be carried out by the department within a period of 60 days from the date of receipt of a certified copy of this order. Any order that is passed by the competent authority in the department, copies thereof must be furnished to the petitioners. Stop. Writ petition accordingly stands disposed of in terms of the above. The department will process the claims of the petitioners in terms of the provisions of Assam Services Pension Rules 1969, read with the amendments made up to date.
60 days from the date of
Receipt of a certified copy
Yes.
of this order. But there is no declaration you are the husband.
Well, no need because in the service record of my name is already
All
there.
right. Declaration is that he is not the husband.
Yes.
Declaration is not that you are the husband.
Well, I never paid for declaration
And
because
that's my submission is that whether the The present position of the pension, I don't have the instruction.
Whatever it is there, if not already released in the meantime.
Not.
But obviously not released, otherwise why will they spend years and years after for a declaration?
I don't have at the moment.